then change your mind in the middle of the trial and nothing comes in, which is what's been happening. Due to a variety, I told you there's no more discussion about this. Of course, ruling stands. But we're missing 2 jurors. We're trying to find them. I remind the parties, this is general voir dire. No one may ask questions about subjects that have already been covered, unless and if a juror spontaneously brings that up. And spontaneously does not mean you asked them a question designed to elicit the answer and then claim it was spontaneous. Stay be prepared to start fairly quickly since I have almost nothing to say to these jurors this morning. I'm going to ask them 2 questions about publicity and that's it. Yes, sir. Thanks. Yes, sir. I cannot.
You are denying access to the record.
I'm not denying you access to the record. I'm denying you going on and on and on about a court's ruling that has been discussed at length. You've made your record. If you have anything else to say, you can proffer it after we're done with jury selection. But remind the attorneys to turn their mics on when you're addressing the court.
Address the court?
Yes, sir.
We are prepared to present witnesses this afternoon based on the schedule. Are we expected to do that? Or do we know?
We will.
Okay. Understood. Thank you.
I don't know how long this is going to take, so based on that, we'll adjust as we go along.
We'll have them ready just in case.
And if you all can stipulate to subjects for opening, I'm fine with that.
Understood. Thank you.
Thanks.
I do have one more question. I'm sorry. I'd like to be able to speak to the jurors about the use of a mask during the ID and opening statements. I don't know if it's in the court's discretion to be able to do that or not, but I'm asking for permission to do that, so long as I stay 6 feet away from anyone else in the courtroom at the time.
I'll let the attorneys take their masks off for general voir dire, but you cannot get close to those jurors. You need to stay away from them, and I'm doing this for the record because we're back in courtroom 23, and there's been so much difficulty with jurors hearing us. The court's had to repeatedly, I've had to remove my mask almost every single time to get them to hear me. So based on that, I'll go ahead and grant the exception to remove the mask.
Yes, sure. Thank you.
Let's start getting them up here. Are we still missing 2? Missing 1. Okay.
Yes, sir.
In light of the email sent by your JA regarding the slides of Dr. Wu, the specific slides, I printed out those slides. I hand wrote the number of the slide that corresponds.
Okay.
Because I meant to print it out with page numbers. I didn't. I hand wrote it. Those correspond in order of the slides mentioned in my motion.
Great.
May I approach?
Yes, sir. And I assume defense has a copy. Great. It's Ted's motion. Thank you. Oh, no. Not tying. What I'm going to do is stand here. It was.
Were you like asking that it'll be on my I know what you guys mean.
They'll be out the door. I said they're there. They're out the door. So, yeah.
So if you launch, you give me first.
Okay. I will.
Take that. Okay, we've begun lining up jurors. Juror 326 in seat 29 has failed to appear. Phone calls have been made. Her phone is turned off. Well, I don't know if it's turned off. It's going directly to voicemail. I'm going to proceed without her. I'll handle her failure to appear separately.
All right, I'm bringing in the juror in seat 25, 118. She has some child care issues she needs to discuss with us.
Can I have a seat here?
Good morning, ma'am. How are you?
Good morning.
Can you hear me with this mask on?
Barely.
All right, is that better?
Yes.
Okay. When you were here last, you had told us your parents could watch your children. Is that correct?
My husband's parents. Or
Your
like-
parent? No.
Yes. Yeah.
Your husband, I just wrote down parents.
That's okay.
Your husband's parents, and I've been informed that there's a problem with that.
Yes. My father-in-law has had a bad reaction to the chemotherapy, so he created blisters all over his body. So, my mother-in-law's taking care of him right now. So she can't take care of my kids in the morning, and my husband goes to work at 4 in the morning. So between 4 and 8 now, I wouldn't have anybody to leave my kids with.
Okay. So you lost your child care, basically?
Yeah, I mean, I can drop them off, but between 4 and 8, I don't have anybody to watch them.
Okay. State, you wish to inquire?
No, Your Honor.
Defense, you wish to inquire? Yes, ma'am. State.
Neither do we, Your Honor.
All right, ma'am. Please don't discuss anything with the other jurors. You're free to go.
Okay, thank you.
All right, we also have a note. Juror 326 has responded to the phone calls, indicating to the jury room that she's in the middle of having a migraine and will not be able to report. State.
She can't be here. I apologize, Your Honor. If she can't be here, we would move for cause.
Defense.
I don't know what the alternative solution is, but I
She
don't.
have no idea. She's either here or she isn't.
I certainly agree with that, but I don't wish to excuse her, but I don't know that there's any other option.
Yeah, I can't make her come in if she's claiming a migraine. Let me just check my notes and make sure she warned us about the migraine thing. I don't have any notes about migraines, but I also don't have any notes that, would indicate that this juror was reluctant. She actually seemed positive about jury service, so I'm going to strike her for cause based on her illness today.
May I just note for the record, my notes reflect that juror in seat 29, 326 was a Hispanic female, and the juror we just struck in seat 25, 118 was a Hispanic female. The majority of the panel is white. Calculation, 40 of 60 folks on this panel are white.
State, any response to that you want to put on the record?
My notes reflect, without any further evidence, that both of the jurors that have been excused this morning for cause were Hispanic females.
Okay,
We're both Hispanic. I have no comment on anything else because I don't know that there's evidence for that.
okay,
Thank you,
thank
Your
you. All right, so at this point, we have all the jurors. We just need to line them up and get them in here. Thanks.
I just want to make sure about that one.
Okay, so, hang on,
Okay.
you're ready with your
Okay. Yes, ma'am.
Everyone remains seated when the jury's coming in and out. What? We seem to have lost a juror somewhere between the jury room and up here. We'll be with you in just a minute, folks. He checked in. So we're actually missing 3 of them? No, we're just missing 1. Yeah. Anything from the juror? All right, we're going to start without the juror in seat number 6. He's been ordered to the courthouse. We'll deal with him when he gets here. All right, folks, if you'll stand, raise your right hand, face the clerk, you're going to be re-sworn.
Do each of you solemnly swear that you will answer truthfully all questions asked of you as prospective jurors, so help you God?
Have a seat, everyone. Good morning.
Good morning.
Welcome to what will hopefully be the last day that you have to wear those masks. All right. We are going to have some questions for you today. They will all be as a group. I have very few questions for you. This will mostly be conducted by the attorneys this morning. The same rules apply as always. Please speak up. I have given the attorneys permission to remove their masks while they're questioning you so that they can be heard clearly. You will be using microphones this morning. The attorneys will maintain a 6-foot distance from all of you, but you will be using the microphones again to answer the questions so that we can hear you. By show of paddles, is there anyone on the panel who has seen or heard anything about this case, had anyone talk to you about it, or anyone try to talk to you about it, or read anything? If you have, please put your paddles up. Court sees no. Juror in seat number 60. Hold on one second, ma'am. Without telling me what you heard. Okay.
Without telling you what I heard?
Don't tell me the contents of it. Just tell me, did you hear, see, or read something about this?
Not lately, but when it first started, I did hear.
Oh, no. I meant since you were here
Since
last in
Friday,
the court.
no.
Okay, thank you. All right, is there any juror who's had a change in circumstances from the last time you spoke to us that you need to bring to the court's attention? All right. Juror in seat number 4. What's your change, sir?
New development at work came up, being assigned to go to Jacksonville for a special assignment on November 8th. I don't know how this is going to work out with the timeline.
What happens if you don't go to the assignment?
I have to go and support the hotel there.
No, my question was, what happens if you don't go?
Not sure what's going to happen. They probably have to find someone else.
Okay, thank you. Anybody else in the front row? Juror in seat number 5.
Had a job change, but I should be good.
Okay, thank you.
I just won't be paid, that's all.
So is that, no, pass it back. If you're not paid, can you, you're
Yes,
saying you won't be paid?
I'll be fine financially.
Okay. All right, thank you. On this row, juror in seat 13.
Last Thursday, I had COVID symptoms. I went and got tested. It was negative. They said I had an upper respiratory infection, give me a round of antibiotics. I still don't feel well.
Okay, how are you feeling? How are you feeling today?
A little dizzy, honestly.
Okay. Thank you, sir. Who else? Next row. Third row. Third row is 31 through 45. Last row, 46 through 60. Juror in seat 53. Yes, ma'am.
I no longer have my job.
You what?
No longer have my job.
Oh, when did that, sorry to hear that. When did that happen?
Friday was my last day.
Okay. Has that changed your current financial situation?
I could pay for a few months. I just have to look for a job well.
Okay. Can you begin a preliminary job search online?
Yes.
Okay, thank you, ma'am. Anyone else in that row? I saw some other paddles up. Juror in seat 58.
Hey, good morning. It's not necessarily a change. It's something I really didn't consider, I think, fully on Friday. My wife and I have two kids, a 2-year-old and a 6-year-old. Our 6-year-old's autistic, and we can, I think, get through the day-to-day with that. The part I didn't consider, though, is that he withholds bowel movements, and that's something that requires a liquid suppository 1 to 2 times a week. It's not something that my wife can apply on her own. It takes both of us. He fights this. And even though, we have her mom lined up to come down and support as much as possible, she's not going to be able to help with that.
Okay, thank you, sir. Juror in seat 59.
Yes, just like 58, I didn't consider it. I'm on FMLA at my job, so I do have episodes where I might miss a day or so of work, but it's controlled with medication. I just wanted you to be aware of that.
All right, thank you, ma'am. Juror in seat number 60. Yes, ma'am.
Yes, ma'am. As of Friday, I contacted my job and they said I would get paid, but they emailed me back and said they will only pay me for 10 days. So with that being said, and you said maybe 3 weeks, that will put a financial strain on me.
All right, thank you, ma'am. Anybody I missed? All right, folks, I don't have any other questions for you. I'm going to turn this over to the attorneys. Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning. Congratulations. Right. As I told you, some of you 2 weeks ago, some of you last week, my name is Ryan Williams, and I'm one of the 2 prosecutors that's assigned to prosecute this case. A few preliminary conversations or statements maybe. By now, you've no doubt seen the computer sitting in front of both myself and Mr. Buxman. If you're selected as a juror in this case, you will no doubt see it sitting in front of us for the remainder of this time. I assure you that we are not doing our early shopping for Christmas or anything else. It's just that which you should do according to local news stories. Most of you are nodding your heads and know what I'm talking about. But this is how we communicate with our office to make sure that witnesses are ready and that things go as smoothly and quickly for all of you as possible. I assure you that between the 2 of us, we are paying attention, we know what's going on, and please don't hold that against us. The second thing is, if I make any other lame attempts at humor during this process, please do not think that I don't take this situation very seriously. I can see the faces of every one of you this morning because of those masks, and I know that you all take this very seriously. It is a very serious situation. However, and I'll add to that after this morning, it is unlikely that you'll see me smile again for the next 2 to 3 weeks. However, it has been my experience, having done this for a little while now, that when people are comfortable and laughing even, they're much more likely to tell us how they really feel about certain topics, as opposed to being buttoned up and thinking you know what the right socially appropriate answer is in front of your 59 new closest friends. So this is my way of imploring you not to give us that answer. Just like it has been throughout the last 2 weeks, there is no right or wrong answer to the questions that we ask, so long as they are your truthful opinion. And some of these questions will just be opinion questions. So if I try to make light of a situation or entertain you, dare I say, a little bit this morning, it is not because I don't understand the gravity and nature of why we're here. It's just that I want you to be comfortable so I can get those truthful answers. Okay. So to start out, here I am saying I'm going to smile and maybe entertain you, and I'm going to start out asking you a very uncomfortable question. And most times what I will do is I will start on the left-hand side and ask that you raise your paddle. And then once I call your number, because I am taking notes, you can put your paddle down, and then I'll go to the right-hand side and do the same thing. So my first question is for the left side of the panel, and this came up with some of you individually, but not all of you. Obviously, one of the offenses in this case is first-degree murder. I will tell you that on almost any first-degree murder or any murder that happens in Central Florida, autopsy is performed by a medical examiner, and in almost every homicide case that is presented, selected photographs from that autopsy are going to be admitted evidence, and you're going to be asked to look at those photographs. The question is not whether you want to do that. I think we can all appreciate that no one wants to look at those photographs. My specific question on the left-hand side is, does anyone believe that they could not look at photographs of a somewhat graphic nature without getting physically or emotionally ill? If you think you could not do that because you're going to get physically ill or become so emotional you can't concentrate, on the left-hand side, could you raise your hand? All right, I see no hands raised. On the right-hand side, does anybody feel that characterizes the way you would feel? I see no hands raised. All right. Second question is also a somewhat sensitive topic. So because there are 60 of you, if the topic or your answer to this question is sensitive in nature that you don't want to discuss it in front of everyone, please let me know that, and we may be able to take that and get your response in a more private circumstance. So my question is, and it's to the left-hand side first, have you or anyone close to you been the victim of a person's crime? And when I say person's crime, what I'm looking for is someone physically put their hands on you or your loved one, threatened you with a weapon, anything like that. I'm not talking about somebody broke into your car and stole some change out of the coin bin. Not that that's not serious, but that's not what I'm interested in. So the question on the left, you or someone close to you have been the victim of a person's crime, if you could raise your paddle. I see no hands. All right. On the right-hand side, you or someone close to you have been the victim of a person's crime. Okay. So I see a paddle from juror seat number 8. You can put your paddle down. Is that seat 11? Okay. Seat 13. Thank you, ma'am. In the third row, seat 38. In the last row in the back, seat 54. Thank you, sir. Seat 56, and seat 60. Now, I'm aware that some of you brought this up to us during the individual process, and if you did, I will not ask you detailed questions about that. So I'm going to start. I'm just going to go numerically and start with juror in seat number 8. Ma'am, is that something that you can tell me about in front of other people, or would you rather do it in private?
I'd rather not talk about it. I did.
Ma'am, you need to use that microphone. I can't hear you. Sorry.
I'd rather not talk about it in front of people, but I talked to y'all about it individually.
You discussed it with us previously?
Mm-hmm.
Yes, ma'am. Understood. Thank you very much for that response. Juror in seat number 11? Yeah. Is that something you can tell us about?
In private, please.
In private? Yes, ma'am. Thank you. See, very easy to say that. Yes, yes, sir. Seat 13. Okay. Seat 38.
Does this include a verbal threat?
If I asked a question and it came in your mind, then yes, sir. So can you tell me about that, or would it be you need to do it in private?
I was threatened at work, my work.
Yes, sir. By a coworker or someone else? Okay. How long ago did that occur?
Several years. 20-some years.
Okay. Was the nature of the threat such that you informed law enforcement about it?
No.
Okay, so you never took a report, anything like that? All right. Anything about that situation and your being threatened that you think would prevent you from being a fair and impartial juror in this case? All right, thank you, sir. Juror number in C54, you also raised your paddle. Is that something you can tell us about?
In private, but does it matter like if it was in a different country?
No, sir. If it affected you or someone close to you and you feel we need to know it, then that's something we'll discuss in private.
Okay.
Thank you, sir. I also saw a juror in seat 56.
Private as well, please.
Okay. And then juror in seat 59 is a new paddle number. You have your paddle up, ma'am?
Yes.
Okay. Can you tell me about that, or do you need to discuss it in private?
Well, it was a workplace assault from a customer.
Okay.
And yes, it was over about 7 years ago.
Okay. Was law enforcement contacted?
Yes.
Was action taken against the person? Were they arrested? Do you know?
Well, at the time I said I would press charges, but everything I think just fell through the system because I get a letter in the end saying that I think time ran out or something, but nothing was ever done to my knowledge.
Okay. You said that you would press charges, or that you told someone that you would.
Right, when it happened,
Yes,
I
ma'am.
said, call 911, I want to press charges.
Right. Did police come out to your place of business?
They did.
And did you write a statement or something?
I did make a statement.
All right. Did you feel that law enforcement acted appropriately in that circumstance?
They did.
But then you said that the system...
Meaning that I was told that to call the state attorneys.
You can say it, it's okay. I won't take it personally. I don't think it was me, but...
And I had somewhat communication, and it just, I don't think nothing ever came of it. And then maybe like I kept asking about it, and then maybe later or so I received something saying that basically the time lapsed and nothing happened to my knowledge.
That was here in Orange County?
Yes.
Given that you wanted prosecution and that it did not occur for whatever reason, how did you feel about the fact that the ball was dropped? I'm going to be blunt about it.
I mean, I was just more so angry when the incident happened because it wasn't even directed towards me. I just happened to be the person sitting in the way, you know what I mean? So I was absolutely angry at that time. So much time had lapsed. I was dealing with other things that, I mean, it didn't really affect me that.
Okay. Anything about the fact that the state attorney's office dropped the ball that you're going to hold against Mr. Buxman or I?
Absolutely not.
Thank you very much. And I'll come back to you in a moment, ma'am. Juror in seat number 60, you raised your paddle. Is that something you can tell us about?
Sure. Mine was domestic in nature.
Okay. How long ago?
Probably about 20 years.
Was the person responsible arrested?
Yes, he was.
And was he held responsible by the court system?
Yes, he was.
Anything about that incident that you think would prevent you from being fair and impartial in this case?
No, I was happy with the outcome.
As a victim, you felt you were treated fairly?
Yes.
Okay, thank you, ma'am. And then I also saw a belated paddle, which is just fine, from seat 30, because sometimes things don't pop in your mind right away and you hear other people talking about it. That's absolutely fine. And I'll get to you in just one moment, seat 43. Juror in seat 30, can you tell me about that?
Yeah, sorry. I was actually held at gunpoint like 11 years ago.
Okay, that definitely qualifies.
I just don't think about it. It's been so long. It was at a job. I used to work at a gas station, and it was a robbery. And it was reported, and I never followed up to see if the person was caught or not.
Was that here in Orange County?
It was in Seminole County.
In Seminole. You said law enforcement responded. Were you pleased with the way they conducted themselves?
Yeah.
Right. Anything about that obviously horrific experience that you think would prevent you from being fair and impartial in this case?
No.
Okay. Thank you, ma'am. And now going back to seat 43, I believe. Is that something you can tell us about, or would you rather do it in private?
I can tell you about it. It was a sexual assault that happened. It's been 7 years now.
And were you the victim?
Yes.
Sorry to hear that, ma'am. Was it here in Orange County or somewhere else?
It was in Jacksonville.
Was the person responsible arrested?
No.
All right. Did you report it?
I did.
Anything about that experience that you think would prevent you from being fair and impartial in this case, which obviously does not involve those facts?
No.
Okay. Thank you for letting me know that, ma'am. Anybody else? Okay. Seat 2 down front, and I also see seat 52, ma'am. I'll come to you in a moment. I'll start with seat 2.
Thank you. It was attempted armed robbery about 12 years ago.
Were you the victim, sir?
Yes, sir. Someone came into my house while I was sleeping and held me at knife point.
Were you the only person in the house at the time?
Yes, sir.
Did you report that to law enforcement?
Yes, sir.
Was the individual caught?
No, sir.
Were you satisfied with law enforcement's efforts to apprehend that person?
I did the best I could.
Okay. Anything about that experience that you think would prevent you from being fair and impartial in this case?
No, sir.
Thank you, sir. Thank you for letting us know.
You're welcome.
And seat 52.
Oh, yes, I got my wallet stolen from me at mugged, I guess, would be the right term.
Okay. How long ago, ma'am?
I think it was about 10 to 12 years ago.
And was that here in Orange County or somewhere else?
It was somewhere else.
Was the person apprehended?
Not that I know of.
Did you let law enforcement know what happened?
Yes.
Were you satisfied with their efforts?
Yes.
Anything about that experience that you think would prevent you from being fair and impartial in this case?
No.
Thank you, ma'am. Seat 42 also raised his paddle.
It's been about 3 years ago, 2, 3
Said
years
three?
ago. Hmm?
Said 3 years ago?
Yeah.
Okay, go ahead, sir.
I was asleep and I kept hearing the doorbell ring, so I thought it might be my brother or niece locked herself out. And by the time I got to my bedroom door, somebody kicked the front door in. But it only lasted about 3 seconds, maybe. I barely did see him. I didn't have my glasses on, so I couldn't give a description when the sheriff came.
So was it your perception that when they saw someone was home, they left?
Yeah, he turned around and ran as soon as he...
Okay, and you mentioned the sheriff and a description, so you notified law enforcement?
Yeah, I notified law enforcement, but I couldn't give him a description because I didn't have on my glasses.
Yes, sir.
I mean, I could see there's a person, but...
Anything about that experience that you think would prevent you from being fair and impartial in this case?
No, it only lasted a few seconds.
Thank you, sir.
Mm-hmm.
Anybody else that had a situation like those that have been described that think we need to know about at all? Okay, I see no hands. On the left-hand side now, the question is, and this is another one where if you don't want to talk about it, I understand, just let us know. You or someone close to you had been arrested or convicted of a crime that you know of the circumstances of. If you could raise your hand on the left. I see a couple of slow hands. All right, I'm gonna call out your paddles. I see 21. Yes, ma'am. 34, 49, and 36. Okay. Juror in seat number 21, is that something you can tell us about?
Yes, we did kind of speak about it individually.
And if you told me about it individually, then I have notes, and you don't need to tell me about it again.
Okay.
But thank you for letting me know.
Thank you.
Seat 34.
Yeah, you said arrested of a crime?
Yes, sir.
Yep, college, couple different instances involving drinking.
Okay. So I'm assuming you're referring to yourself personally.
Sorry?
You personally?
Yep.
Okay. Anything about the way you were treated by law enforcement that you believed was unfair? You can say it was, it's okay.
There was, yeah.
Okay, tell me about that.
This was going back probably 19 years old, but we were at a house party drinking underage that got busted, and I happened to kind of get thrown around. We were hiding, so I got thrown around a little bit and was accused of resisting arrest for hiding.
Okay.
So it wasn't the best experience.
Yes, sir. And if those of you who have answered this question already or heard me ask the question about whether you were treated fairly, you may understand why I'm asking, because as you can imagine, there are going to be law enforcement officers come in and testify witnesses in this case. Let me ask one more general question before I come back to you, sir. Does anybody here think that all law enforcement officers are good? Raise your hand. All right. Seat 32, you think all law enforcement officers are good?
The majority, yeah.
No, I said all.
All?
All.
Well, no, never mind.
Yeah, retract that. There we go. Does anybody here think that all law enforcement officers are bad?
Raise your power, less than high.
Nobody? Okay. So, law enforcement officers, in my experience, are like plumbers or anybody else who does their job. Some of them are really good at what they do, and some of them not so much. And some of them do outright unlawful things. And that is nothing to be ashamed of, and this conversation is not one that everybody needs to be on pins and needles about, because we recognize that, okay? But we need to know, is if something happened in your life that's going to color the way you view any certain situation. That's the reason I'm asking these questions and going one by one. So my question for you, you're in seat number 34. It's so much easier if I could use your names, but I'm not going to. I'll call you Mr. 34. Given that you were treated unfairly by law enforcement, what you say at face value, would you hold that against the law enforcement officer who testified in this case just because he or she was a law enforcement officer?
No.
All right. You think you could set aside that experience and fairly and impartially weigh their testimony?
Yes.
Okay. Thank you, sir. Seat 36, 2 people over. Can you tell me about that experience?
Yes. It was my nephew. He was arrested for drugs in Texas.
Okay. What do you know about that circumstance?
I just know he went to jail for drug use. And he is currently out now, so.
Okay. Do you know enough to say whether he was treated fairly or not?
No, I do not.
Okay. Anything about your nephew having been arrested that you think would prevent you from being fair and impartial in this case?
No.
Okay. Thank you, sir. Seat 49. I'll come back to you. 32 just raised her paddle. Seat 49. Yes, ma'am.
My boyfriend?
Okay. Your boyfriend was arrested?
Yes.
All right. How long ago?
Many years. It was before he met me, so I don't know exactly how many years ago.
Did he tell you the details of that experience?
No.
Do you know enough about it to know whether he was treated fairly or not?
I guess he was treated fairly. He deserved it, so.
Okay. Anything about the fact that he had been arrested in the past that you think would prevent you from being a fair and impartial juror in this case?
No.
Thank you, ma'am. Seat 32 also raised her paddle. Yes, ma'am.
My significant other.
Okay. Do you know how long ago it was that occurred?
It was before we met. And we have been together 8 years now.
Okay. Has he shared or she shared the details with you about that?
All I know is involved robbing, he rode a four-wheeler. A four-wheeler.
The allegation was that he stole a four-wheeler?
Yes.
Okay. Did he share with you whether he believed that he was treated fairly or not by law enforcement?
He told me that he has been treated fairly and not fairly, but he hasn't given me details. I just rather not ask.
Understood. Anything about your knowledge, your limited knowledge of the circumstance that you think would prevent you from being fair and impartial juror in this case?
No, absolutely not.
Yes, ma'am. Thank you. Seat 4, down front on the left still. Tell me about that, sir.
DUI,
You personally?
yes,
How long ago?
probably over 20 years ago.
Did you feel like law enforcement treated you fairly?
Yes,
Anything about that experience that you think would prevent you from being a fair and impartial juror in this case?
no.
Thank you, sir. Anybody else on the left-hand side? Seat 2. Yes, sir.
Also charged with DUI.
Okay. How long ago?
This was 15 years.
Here in Orange County or somewhere else?
No, it's Mississippi.
Mississippi. Really, because you have like a Boston accent.
Oh, yeah? Never got that one.
That was one of those jokes I was talking about.
Yeah.
Bad one at that. Anything about that experience that you think would prevent you from being a fair and impartial juror in this case, sir?
It used to, because it was not right. There's a lot of stuff behind it. I wasn't under the influence, but it was a small town, bunch of cowboys over there.
Yes, sir.
Things happened and I've let it go, so it won't cause any problems.
Thank you for your candor about that. Anybody who's driven through a small town in Mississippi knows what you're talking about. Anybody else on the left-hand side? On the right-hand side, I'll restate the question because it's been a while since I said the original question. You or someone close to you was arrested or convicted of a crime. And the reason I'm asking, hold on one moment. The reason I'm asking is to make sure we can ask you those questions about witnesses and the ability to gauge their credibility. So on the right-hand side, raise your paddles again, and when I call your number, you can put them down. Seat 8, seat 11, seat 12, seat 14, seat 23, seat 24, seat 28, seat 9. In the back row, I see seat 56, seat 57, and seat 58. Did I miss anybody for now on the right-hand side? Seat 13. Yes, sir. Thank you. Okay. It's okay. We'll go through it one by one. It's not a problem. Seat 8. Is that something you can tell me about, ma'am?
Yeah, my husband was arrested for DUI about 15 years ago.
Okay.
And my brother was arrested on drug charges some many, many years ago.
The second one was your brother?
Mm-hmm.
Is that a yes?
Yes.
Just for her. That's all. Thank you. Anything about your husband's arrest that you think he was not treated fairly or that he expressed to you he was not treated fairly?
No.
All right. What about your brother's situation? No. Is it your view, and if I'm wrong, tell me, is it your view that they were both treated fairly by law enforcement?
I wasn't there, so I don't know, but they didn't say to me anything like that.
But they didn't express negative treatment to you?
No.
Okay. Anything about those circumstances that you think would prevent you from being a fair and impartial juror in this case?
No.
Thank you, ma'am. Seat 11, actually seat 9 was the next person. Yes, sir.
My aunt served, when she passed away in federal prison.
Okay.
I was young, so I don't know anything about it except for we used to go visit her.
Okay.
And then both of my cousins were arrested, and one was for drug charge and one was for assault. I don't know anything more about that. That was on that side of the family that we didn't hang out with.
Okay. Anything about either your aunt's situation or the situation with your cousins that you think would prevent you from being a fair and impartial?
No, my aunt was grateful that it happened, believe it or not, so it changed her life, so.
For the good?
Nope, it was my, It was good. My cousins, I don't know the circumstances with them. I just know that's where they were. And Christmas time, we'd get a phone call when we were all sitting around having Christmas dinner.
Okay. Thank you, sir. The next number I have is seat 11. Yes, ma'am?
Yes, sir. As pertaining to the situation that I talked about with you all in private.
I'm sorry,
yes.
ma'am, I can't hear you.
Sorry. It was pertaining to the situation that I'll talk with you all in private about.
Yes, ma'am.
And yes, individual was arrested.
Okay.
To my knowledge, he was treated fairly.
Okay. And what we'll do, ma'am, is we'll just talk to you about all that when we speak to you in private. But thank you for notifying me about that. C12. Yes, ma'am.
You actually have all the notes from
You
my
discussed it?
individual.
Perfect. Thank you very much for letting me know. C14. I'm sorry, 13. 13 first. Go ahead, sir.
Mine's also pertaining to the previous matter.
Okay. Yes, sir. Now C14.
Yes. My mother, she was arrested for threatening someone with a weapon.
Okay. How long ago, sir?
This was about 15 or 16 years ago.
Was that here in Orange County?
Yes.
You'd have been at least a minor at that point.
Right, yes.
Did you witness the situation?
I did witness it, yes.
You did, okay. Did you feel like she was treated fairly?
Yes, she was treated fairly.
Anything about that situation that you think would prevent you from being a fair and impartial juror in this case?
No.
Thank you, sir, for letting me know. The next number that I have is 23.
We spoke briefly about my family.
We did, I remember that.
And I got a lot more on that, but I was also arrested. It was a dispute over a dog. I've never owned a registered dog before, and the girl I was with registered the dog in her name, and we went to separate it. Obviously, I stopped her. I got arrested because it was registered to her. All charges were dropped. I also now have the dog, which cost me another $1,500 to pay her out, and $3,000 in vet visits for an 8-month-old puppy. So.
But you're not bitter about it at all.
No,
I'm just joking, sir.
The dog had some major issues. I'm glad I got her back, and I would do the 3 days in jail again any day of the week for the dog. So.
You're a better man than I. But so a dog. I didn't know you had to register a dog either, or that you could do that.
Well, yeah. So I guess if it's a pure breed, you register it, and that registration is, like the officer said to me, it's just like a car registration. I said, I've got receipts for everything. The officer said, too bad, you're going to jail. Okay. Which I'm perfectly fine with that. I understand. And the outcome was perfectly fine. It was in Seminole County. All the officers treated me very well with respect.
Okay.
I just got to say, I heard from people in Seminole County Jail, it's so much better than Orange County Jail. So I guess I had the luxury resort. I'm not jaded by any sense. It won't affect my ability in this.
Okay.
Law enforcement did the right thing, so.
Thank you, sir. Thank you for letting me know. Well, yes, sir, C24.
I think we spoke about it. It was with my brother. He was arrested in Pennsylvania.
We did. I remember now. Thank you. C28.
Okay.
You're going to have to do a whole lot better than C23.
It'll be a challenge.
Yes, sir.
But I believe the quote is, when I was young and reckless, I was young and reckless. This would date back to when I was 18, and me and a buddy decided it'd be really cool to have a couple of street signs as ring decorations for college. Unfortunately, we were both total nerds and didn't know the first thing about how to do it correctly, and wound up getting pulled over by friends in St. Cloud at the time. So arrested, not convicted. Nothing about that experience will change any of my views on this case.
Because it's your fault for being a bad criminal.
I was a very bad criminal.
Understood. Yes, sir. Thank you. Now C28. Then the next number I had was C56.
It's related to the other incident, so wait till private.
Yes, sir. We can discuss it then. Thank you. 57. You cut out there for a second, ma'am.
Testing? Okay.
Nope.
Try holding it to the side.
My husband's parents were arrested for domestic violence charges.
Yes, ma'am.
But it was like 20 years ago.
All right, and I'm just going to repeat that so that she can take it down. Your husband's, if I misstate it, tell me. Your husband's parents were arrested for domestic violence about 20 years ago? Okay. Anything about your knowledge of that situation that you think would prevent you from being a fair and impartial juror in this case?
No.
Thank you, ma'am. Seat 58.
I'm sorry, I can't hear you.
Okay. Yep, we're going to go with it's the mic since the both of you got it. Please repeat, sir.
Yeah, so there's two. One for myself. In 1998 and 99, I was arrested in Jacksonville for drunk and disorderly. I was treated fairly. There was no bad feelings about that. There's nothing that would impact my feelings now towards this case regarding that. The other is for my wife. She was arrested 2007 or 2008. She had, this was before we were married. She got addicted to painkillers. She got to the point in her addiction where she was selling painkillers to support her habit. She sold to an undercover officer, was arrested, charged. There's nothing with that she was treated fairly, as far as I know. I think in the long term it ended up helping her. She's been clean for over a decade now, so it turned out okay, and there's nothing in that for me that I would have any bad feelings or ill will towards.
I understand. Thank you, sir.
Regarding this.
All right. Anybody that I missed or for whom this conversation has sparked something in their memory? All right. I see no hands. Other than the people who have already discussed this topic because of the prior question, on the left-hand side, has anybody had a really bad experience with law enforcement? If you could raise your hand. All right. Seat 32. And then I'm talking about anything like even a traffic stop where you were treated so rudely that you never thought about a traffic stop the same, by way of example. Yes, ma'am, seat 32. Can you tell me about that?
I will say this was like 10 years ago. I moved from Puerto Rico here finally, and I started a job which I misplaced my driver's license. So I was on my way back home, and I didn't know that when there was a police car with the lights on, that I have to move to the side and continue driving. So I just slow down and continue. Well, he stopped me, and because I didn't have my driver's license, he didn't believe that I was myself. I gave him my social security number, my birth certificate. He threw my birth certificate literally on my face, saying that it was in Spanish. And I was like, if you look very well, it's in Spanish and English, because from Puerto Rico, we speak both languages. And literally yelling, he called more police officers on me. I showed him my divorce papers, everything that I could show him, but he still, he gave me a citation. He took my car's license plate. He made me go to court. For me, it was a nightmare, because for me to prove that I was myself, I had to go to the Social Security office. Mm-hmm. I didn't have a formal ID to show other than my divorce papers and my birth certificate. They made me go to a place for me to do a physical, which they needed my driver's license.
Right.
But thankfully, they had records that I had been there before. But he did make my night a living hell that night.
Right.
I'm still not losing faith on law enforcement, but it was not a great experience for 3 weeks.
Right. I'm sorry to hear that, and it goes to what I was talking about, good and bad.
It's an experience. That's all I have to say.
And you alluded to it, but it sounds like it would not.
Oh, no, absolutely not.
Okay. Thank you, ma'am. Mm-hmm. On the left-hand side, anybody else have an experience similar in nature or otherwise that you think we should know about? I see no hands. On the right-hand side, I see a reluctant paddle, seat 43.
This is pertaining to what had happened with my sexual assault. I had called police at the time after it had happened. And I was told that there was nothing that could be proven, so it was not worth it for me to put in a statement of any sort. It wasn't, I would say that like now, it's not something that would ever affect me in a case like this. But at the time, it wasn't something that I needed to hear. I know that it was just in like my best interest. They didn't want me to have to go through saying everything over and over again, but I think at the time it wasn't something that I needed to hear from a police officer.
Okay, thank you, ma'am. Anybody else on that topic on the right-hand side? I see no hands. All right, this is going to sound silly, but I'm going to ask it nonetheless because it's Monday. On the left-hand side, raise your hand if you really hate working in a group. Does anybody just really despise working in a group? So in school, high school, college, even now professional, you know, if you have to do a group project and collaborate with other individuals, that kind of thing just rubs you the wrong way because there's always somebody who doesn't do their fair share of work or somebody who knows everything. Anybody feel that way on the left-hand side? On the right-hand side, everybody gets along with everybody all the time. That's amazing. There's a pal in the back, seat 57.
I mean, I feel bad because no one else raised their paddle, but I mean...
No, you're just being really candid, that's all. Go ahead.
I mean, I was just always in the situation where people, I've always had to pick up...
I'm sorry, ma'am, I can't hear you.
I'm so sorry. I've always had to pick up the slack and just don't really, kind of a control freak, which is a personal issue, but just don't enjoy it.
So you prefer not to work in groups for that reason. Is that a fair statement?
Yes, sir.
Okay. All right. Now that brave juror number 57 said something about her personality, does anybody feel the same way, even similar to juror seat 57? On the left, or had an experience? I see no hands. On the right? Okay. So let me go to juror in seat number 10, number 68. Yep. Out of the blue, I just called on you. Sorry about that. How do you feel about working in groups? Let me ask a first question. Have you had that experience before?
Yes.
How was it for you? Do you enjoy it? Would you rather work by yourself? Tell me your thought process on that.
For me, a group would offer more ideas and ways to think about things. So I kind of enjoy that.
Okay. Did everybody hear what juror in seat 10 said? No, I see you shaking your head. That just means I'm going to ask you how you feel about it. So somebody passed. One of the cardinal rules of jury selection is not to make eye contact with me or make a physical expression. Could we hand the mic to juror in seat number 21? Yes, ma'am.
Can you repeat the question?
I will. Sure thing. The question is, have you ever worked in a group setting where you had to accomplish a task or a goal? And if so, what are your thoughts about working in a group as opposed to working on your own?
For the most part of my adult life with work, I have to work in groups and multidisciplinary staffings. So I work really well in groups and independently.
Okay. What about next to you, juror in seat 22? Have you ever had that experience? Why are you laughing?
Because you said not to make eye contact, and I wasn't looking, I just kept choosing.
Well, the other thing not to do is to try to avoid eye contact with me. Because that'll happen too. Yes, ma'am. Have you ever worked in a group?
In school.
In school, okay. And I never guess a woman's age, so how long ago was that you did a group project in school?
18 years.
Okay. Did you enjoy the experience?
I do.
Would you rather?
I like people.
I'm sorry?
I like people.
You like people?
Yes.
All right. That puts you in the minority, just so you know. What is it that you like about group projects and working with people?
Actually coming together to get like science projects. Those were the best.
Okay. Why science?
But we had to do like make little volcanoes or just
the lab projects.
Yes.
Yes, ma'am.
Those
Okay.
were the best.
Right. So you have no problem, I take it, that you like people making group decisions and having that dynamic.
Correct.
So I'll ask it a different way. Does anybody here, and we'll start on the left-hand side, just prefer to make decisions on their own? Not that you don't like group projects, but you'd rather just make your own decision without a lot of input from anybody else. My wife was here, she'd raise her hand right now. I know that from experience. On the left, does anybody feel that way? Juror in seat 32 and 34? Of course you can explain. Seat 32 is who I'm about to speak to. Yes, ma'am.
I work with the group. I'm the lead agent in my group. Yes, I rarely make my own decisions. However, I do listen.
Okay.
And I do have a wonderful group. I love working with my group. And whenever we don't come up with a decision, we always sit down, have our team meetings every week. We express ourselves. I listen, they listen to me, and we always come up with a decision at the end. But as a person, I don't think that nobody will disagree with saying I like to make my own decisions.
Oh, people can disagree with anything.
Well, it could be. But in my case, I would say both.
Okay. Seat 34, can you tell me about that, please?
Yeah, I think similar. I'd echo that. I think, I'm open. I work with a lot of groups. I'm open to a lot of perspectives. But at the end of the day, when it comes down to making certain sets of decisions, I really prefer, my own judgment. I like to make my own decisions.
All right. What about you, seat 1? Can we pass the microphone to seat 1? You just got called on because I don't want to forget you because you're in the front left. So I thought of you in a moment and I just said it.
Appreciate it.
You're welcome. Go ahead, sir.
I work in a group every day at work, so I'm very used to it. I don't mind making a group decision or a personal one.
Either way is fine for you?
Yes.
Okay. So if selected as a juror, we're going to switch topics now and get away from this group conversation. If selected as a juror in this case, you will receive an instruction that gives you some of the law about what the law is regarding a law enforcement officer's use of force. Okay? And I probably don't need to tell you all that an officer's use of force has been a major source of conversation in this country and many countries over the course of the last couple of years, which is why I'm bringing it up. Sometimes, and the judge will give you the instruction and the outlines of what the law says when this is appropriate, but sometimes law enforcement officers can use deadly force. By that, of course, I mean force that is either designed to or does bring about the death of another human being. So my question on the left-hand side is, does anybody on the left, if you could raise your power, if you believe that a law enforcement officer should never be permitted to use deadly force to make an arrest? Does anybody feel that way on the left-hand side? I see no hands, but I do see an exasperated look on the face of, now everybody's wondering if they look exasperated. Juror in seat number 5. Can you tell me what you think about the question I just asked?
I'm kind of up in the air.
Okay, tell me about that, please.
Well, force, to defend yourself or others, yeah, I would say using force to a point of death, yeah, I understand that. But to be reckless because of a, superiority over another person, no.
Okay.
I don't believe that.
Did everybody hear what juror in seat 5 just said?
Raise your hand if you generally agree with juror in seat 5. Raise your paddle nice and high. All right? So, juror in seat 24? No, I'm sorry, not seat 24, seat 26. You didn't raise your paddle, was it just because, or can you tell me why you didn't raise your paddle?
Well, I guess it's a personal opinion that you have to look at every fact, every day. I mean, things change.
You okay, Judge? Yes, ma'am. You want me to pause? I'm going to pause just for a moment, okay? Yes, Your Honor.
Sorry. We're going to bring in a juror that was late and swear them in. It also gives me a moment to recover. I have allergies, and this just causes a tickle in my throat. Sometimes I can't stop coughing. I don't want anybody to think I'm sick up here.
Do you solemnly swear or affirm that you will answer truthfully all questions asked of you as a potential juror to help God? Thank you.
All right, have a seat, sir. Mr. Williams, you may resume. Thank you.
Thank you, Your Honor. So I'm sure those of you who watch Law & Order remember the episode where the judge had a coughing fit and we all had to stop? No? Okay. Juror C26, I believe you were telling me about your thoughts on law enforcement and the use of deadly force.
Well, my thoughts on deadly force is, again, you know, different facts. We're not there every day. I can't make a general consensus opinion one way or the other. That's why I didn't raise my paddle. I just can't say, yeah, yes or no.
Okay. What about juror in seat 41? Somebody pass him the microphone. What do you think about the use of deadly force by law enforcement?
It's situational.
Okay.
Sometimes it's required, sometimes it's not.
And next to you, seat 40?
I agree.
You
I
agree?
agree exactly with him. It's always situational.
Okay. So do I understand everyone here, and I'll start on the left-hand side, that there's no one who thinks that law enforcement should never be permitted to use deadly force? You think they should? Right. And that's my understanding. So that was a poor question. That was a poor question on my part. Raise your hand if you think on the left-hand side that law enforcement should never be permitted to use deadly force. On the left, I see no hands. On the right-hand side, does anybody feel that way? All right. Let me go back now to the left-hand side. Raise your hand if you believe that law enforcement uses deadly force too often. All right. So please keep your paddles up until I've had a chance to call your name, okay? Or your number, excuse me. That's seat 18, seat 34, seat 49, and seat 52. All right, can we pass the microphone to seat 18, please? Tell me about your thoughts on that, sir, please.
There's some countries, right, that officers don't actually have a gun.
Right.
But here in this country, people do not allowed to have a gun. But it seems like most of the aggressions against black men, and more often so we are killed by police officers. It could be a simple traffic stop and the guns are pulled out for no reason at all.
So you believe that law enforcement, generally speaking, in this country uses force, deadly force, too often?
Correct.
And do I further understand you to believe that particularly pertains to minority individuals?
Yes.
Okay. Well, it's not rocket science for me to tell you that Mr. Loyd is a minority individual.
Correct.
So my simple question for you is, given your understandable feelings on that topic, do you think that you would be able to fairly and accurately listen to the evidence of any interaction that Mr. Loyd had with the officer in this case and apply the law as you understand it?
Most definitely, yes. I mean, once you put the facts in front of me, I could make a decision based on what's...
And to be fair, I asked you your opinion and you gave it to me, so that's fine. But thank you for doing it.
Right.
34, can you tell me how you feel about that?
Yeah, no, I just think similar. I think my mind jumped to situations. There's always going to be a situation where, you look at it and you don't think it was required, maybe somebody was running away or something like that.
Right.
So I think the media probably makes us jump to an instance where we remember, but I think universally, that, there is a time and a place where deadly force is required.
Okay, thank you, sir. I also, seat 49, also raised her paddle.
Yeah, I feel the same way. Like, I feel some situations could have been resolved without having to get to that extent. But I also understand that their lives, if it's a life or death for them, that is they're put in that situation, then I feel that they can use it. But at the same time, I feel that in other instances, it has been used when it could have been resolved a different way.
Okay, thank you, ma'am. And seat 52.
Yeah, so I wouldn't say that generally deadly force is used inappropriately, but there have been specific instances where I feel like it's been used inappropriately.
Right. Okay. Thank you, ma'am. Same question now to the jurors on the right-hand side. Raise your paddle if you believe that deadly force is used by law enforcement too often. All right, and please keep them up until I call your number. So I'm going to go in numerical order. That's seat 8, seat 15, seat 24, seat 28, seat 43, seat 54, seat 57, and seat 60. Okay, and I do listen to everybody, so if your feelings are encapsulated by someone else's response, feel free to say that. We don't need to reinvent the wheel for everybody. But if you've got something original to say, please tell me. Seat 8, go ahead.
I kind of agree with the gentleman right here.
The gentleman
that spoke.
That would be seat 18, right? Is that you, sir?
Yes.
Yes, ma'am.
Yes, I kind of think it happens a lot more with the minorities than it does,
Right.
any other situation.
Anything else you want to add?
No.
Okay, thank you. The next seat was 15. Go ahead and tell me how you feel about that.
Generally, I agree. I think there's too many instances of deadly force where it wasn't necessary. Not just necessary as a result, but not just getting into that situation in the first place.
Okay, thank you, sir. Seat 28, no, I'm sorry, 24, and then 28.
So, if use of deadly force was too often is the question, and that's, for me, mostly it's in the form of seeing the instances where the person is either is running. I've seen more than I'd like where they kill that, they shoot at that person, which it really just elicits a response of like, it's not supposed to be catch or kill, you know what I mean? Like it's, right. If they're running, I don't think that's, called for shooting, but I've seen that happen, and so because of that, if that happens at all, then it would be too much, if that makes sense. That's my personal, that's the biggest one.
Yes, sir? Yeah. Thank you. C28, if we could pass him the microphone. Yes, sir.
I believe that everyone's opinion that's been expressed here collectively is correct. It is situational, it's a fact-based circumstance, but that you have seen it used too often in certain circumstances, and the protocols need to be there to reduce its use, but not eliminate it.
Okay. Thank you, sir. Seat 43.
I'm the same way as every other juror. I feel like there are times where it's used too often, but it's also very situational. Depends on who's, if there's an officer's life at stake because of it, then yes, deadly force should be required. It should be allowed to be used, but not in all circumstances that we've seen on the rise. Do I feel like it was required for them to use?
Yes, ma'am. Thank you. I'll come back to you, seat 11. Thank you for letting me know. Can we pass the microphone to seat 56? Did you raise your paddle, sir?
No, I did not.
54. 54. I wrote it. I can't read my own writing. Sorry. Go ahead, sir.
Yeah, I have the same opinion, basically. I feel like overall in this country it's used too much, but there's also sometimes where it shouldn't be used, like if they need to defend themselves, or if the person they're trying to arrest also has like a deadly weapon and they have intent to use it, probably.
Okay, thank you, sir. And C57?
I agree with the other jurors that have already spoken.
Okay. Seat 60.
In my opinion, I believe it's been happening the whole time. It's just that now with technology and camera phones, we get to see it so often that it looks like it's on a regular basis. And it's scary when you see it. But it's not only happening to adults, children as well.
Okay. Thank you, ma'am. And seat 11 down front on my right, your left.
I just wanted to let you know that I agree with their sentiments as well.
Okay, thank you, ma'am. Anybody else have an opinion on this topic that they want to share? Because you think it is relevant to the conversation. Right? I see no other hands. Okay. Now we're going to go to a slightly lighter topic after an hour of somewhat heavy conversation. On the left-hand side, raise your hand if you watch a crime scene television show with regularity. Lots of paddles, all right? Keep them up, nice and high. On the right-hand side, raise your hand if you watch a crime scene show with regularity. Okay, I see lots of people. I'm going to go to somebody I haven't spoken to yet. You can put them down. Thank you. Seat 3, down front, my left. How are you, sir? I'm good. That's 2 sirs in like a 5-second span, so well done. Which show is it that you watch?
And Law and Order.
ID and Law and Order, all right? I'm not familiar with ID. What's that about?
A TV channel.
Well, yeah, I mean...
There's various shows on there. The channel is nonstop.
It's a channel?
Yes, sir.
Oh, okay. And it's all types of crime shows? Wow, I didn't even know they had a whole channel now. I'll have to update my spiel here. Okay, so juror in C3, can you tell me, and everybody listen, because this is the interactive portion of the morning, because I'm not just talking to C3, I'm going to talk to others of you as we go. I want you falling asleep and then not knowing what he said. So C3, can you tell me some different types of evidence that you see on these crime scene shows? That's exactly what I mean. So video, first thing you said. What else? Testimony. Did everybody hear that? Is that a yes? All right. What else? Yeah, but what type of evidence? In what form? You talked about video. You talked about testimony. Okay. What kind of physical evidence? Skid marks. Yep. Fingerprints. Weapons? Weapons? All right, thank you, sir. So, juror in C, this is always the danger with an interactive show. Juror in C3 mentioned something that usually takes quite some time to get to. Does anybody hear what it was? Who said that? Nice and loud. That's a hand from, not using your paddle, seat 40. There you go. Seat 40 said testimony. Right, so on the left-hand side, you all understand that in the state of Florida, and to my knowledge, in every court in this country, testimony is evidence. And yes? Yeah. Please answer out loud, that way I know you're awake. On the right, does everybody understand that? Yes. Right. That becomes very important because television shows have conditioned our society to look for these things that juror in C3 was talking about. Video evidence, DNA, fingerprints, and all of those are other types of evidence that are admissible regularly or admitted regularly in the court of law. But it's lost that testimony is evidence. And that's important because if you were listening closely when I read the list of witnesses, there are going to be more than one witness who comes into this courtroom, comes past this gate, and goes past you all as jurors sitting in the box, gets on the witness stand, and tells you what he or she saw. Right? Now, like all evidence, it is up to you to determine whether or not you believe what that person says. Now, we make these judgments every day, right, as people. Can anybody think of a circumstance, everyday occurrence, where you as an individual have to decide whether or not you believe somebody? Raise your paddle. That was a fast paddle. Holy smokes. Juror in seat 47. Let's pass him the microphone. Parenting. Okay, that's an easy one. We'll stick with that one. And actually, right behind that was seat 22. Were you going to say the same thing, or parenting? Right? So those of us with children who have had children in the past or one day want to have children, God help you. I didn't mean it that way. I meant just make sure you start saving now is what I was trying to say. Our children tell us their version of what happened in a given situation, and we have to look at the circumstances, read their body language, determine whether what they're saying makes sense, right? Well, that's your role with jurors. And in fact, the law that you will get from the judge at some point tells you that you can believe some, all, or none of the testimony of any witness. And it's the same thing with fingerprints and DNA. You'll hear from the people who do that work, if it's presented, and decide whether or not they did their job correctly. Right? But it is important that everyone understand that while you determine its credibility, testimony is evidence. On the left-hand side, does anybody have a problem with the concept that a person testifying is evidence in the state of Florida? Raise your paddle on the left if you have a problem with that. I see no hands on the right-hand side. Sure. When I get excited, I start to talk fast, so I'll have to slow down. The question was, does anyone have a problem or an issue with the concept that testimony is in fact evidence in the state of Florida and can be relied upon by jurors? On the left, I see no hands, and on the right. What do you think, juror, just because, so now another rule is if I haven't talked to you yet, you need to be aware that I'm coming to you. Juror in seat number 35. Can we pass the microphone to seat 35, please? Tell me your thoughts about the concept of using testimony as evidence in a court of law.
Well, I would follow what the judge said about the testimony, and as a juror, my job is to I guess, gauge the veracity of that evidence, whether it was believable or not, and possibly compare if this person made a statement and then there's what they say on the stand. Those are all, I mean, circumstances, I believe, that I would need to, I hate to say judge. Your Honor, I promise, I'm not trying to be the judge.
Right.
But that's what I think. I think as a juror, my job is to discern believability versus sort of believability or no believability.
Right. Yes, sir. Understood. Everybody hear what he had to say? Anybody disagree with that being your role? All right. Anybody think they'll have a problem with performing that role if selected as a juror for any reason? All right. Well, let me go to a slightly different question then. And again, try to speak to somebody I haven't, spoken to just yet. Let's see. Juror in seat 6. I'd like you to think of a situation where a witness testifies. Well, I need to back up. So I apologize, but listen to this part too, please. Every crime that is alleged in Florida, there are elements of that crime, okay, which are specific facts that have to be proven beyond a reasonable doubt for a juror to find a person guilty of that crime. Make sense? Yes? Yes. Okay. So juror in seat number 6, let's say a witness came in and testified as to all 3 elements of a specific crime. You listened to the witness's testimony, you accepted it, you believe that the person is telling the truth and that they had the opportunity to observe what they saw. You with me?
Yes.
All right? And what they said meets all 3 elements of the crime. Could you find a person guilty beyond a reasonable doubt based solely on the testimony of one witness? Assuming you believe them.
Yes. If there's one witness to listen to and there was the only witness, then yes. If there's other witnesses, I think that changes the question, the conversation, right?
It absolutely does. That's why I was so precise with the question that I asked. Yes, sir.
Yes, if there's one witness, yes.
Did everybody hear what juror in seat number 6 said?
Yes.
Right? Raise your hand on the left-hand side if you disagree with that. And in other words, even if you believe the testimony of this one witness, it would not be enough for you to find a person guilty beyond a reasonable doubt under any circumstances. All right? I see several hands. So please keep your paddles up until I call your number. I see number 32, 49, hesitant paddle from 34. All right? 49, 50, and 52. All right, so we'll stay on the left and then we'll go. So we could pass the microphone, that's the word I was looking for, to seat 32. So am I understanding that you could not find a person guilty beyond a reasonable doubt based solely on the testimony of one witness, even if you believe them?
That should be some kind of evidence too, because...
Well, hold on, let me stop you right there. Because we just spent about 5 minutes establishing that testimony is evidence.
The reason why I'm saying this is because there are people that are really good liars.
Right.
So evidence and testimonies has to be mixed. That's just my personal opinion.
I understand, and I asked for your opinion, so I appreciate it. So, and I want to be clear. Are you saying that there are no circumstances under which you could find a person guilty beyond a reasonable doubt based upon the testimony of only one witness, even if you believe them?
Yeah.
Okay. Thank you, ma'am. Seat 34?
Yep.
You feel the same way?
Similar, I was thinking just any kind of evidence that that when a crime occurs, there's a person, there might be a vehicle, there might be a building, that any kind of general evidence, but it just seemed that there should be some other evidence. Like the person was actually in the state, for instance.
Well, let me ask you a question. Can you, and I'm gonna be very direct and blunt with my example, okay? Do you believe that child sexual abuse occurs?
Yes.
Right. Can you imagine a circumstance where a child would be a victim of sexual assault and no one would witness it other than the child?
Yes.
And can you imagine a circumstance where not only would they be the only witness, but there was no physical evidence left behind?
Yep.
Right. Do you believe we should prosecute child sexual abuse?
Yes.
Right. So, not to be fair, I asked you all the question in your opinion before I gave you that example.
But there would be other evidence, like,
No, you just told me that there were no circumstances, that there were circumstances where it would only be the child and there could be no physical evidence. Right? Now, I can tell you that, but it's different for you to be able to process it and say, yes, for me, I could do that. So my question for you, seat 34, is, assuming you believe the witness, could you find a person guilty beyond a reasonable doubt based only on the testimony of one witness?
Yes, along with supporting facts like the defendant was in the country or state, it would be evidence.
Okay, I see what you're getting at. Yes, sir.
There'd be other evidence that, supported the defense.
Okay. I also had a panel from seat 49.
The same thing. It's going to be hard just for just one testimony if it's not also with other evidence involved.
Okay. Hard but not impossible.
Yes, super hard.
Super hard.
Okay. Because there's a truth, the other truth, and the real truth. So it's going to be hard, one word against another word, and then not backed up with something. You can believe them, but it will be like more convincing if you have facts proving what they're saying.
Yes, ma'am. All right, seat 50. It's not working.
Can't hear you.
Hello? There we go. Okay, great. Similarly, if not same, I think what's catching me is the beyond a reasonable doubt. And I think if it's one person and it's their perspective and they're sharing that, even if they believe it and I believe it, it would be very, very difficult to say beyond a reasonable doubt.
Difficult is different than impossible.
Yes.
So you're not saying it's impossible?
Not impossible. Very difficult.
Yes, ma'am. Understood. Yeah. Thank you. And seat 52.
Similar to other jurors, if we're saying impossible, well, can you repeat Can you repeat the question specifically?
Yes, ma'am. Could you find a person guilty beyond a reasonable doubt based upon the testimony of only one witness, assuming you believe that witness's testimony and their testimony establishes all the elements of the crime? That's a long question.
So I think that there could be situations where I do believe someone, I do believe their testimony, but they may not have, it's their perspective. So there may be other pieces of the crime that...
You're good, keep going.
There may be other pieces of the crime that the witness, maybe they're not a full witness to the crime. Maybe they're a partial, they only saw part of it.
Right. But in the hypothetical I gave you, they saw it all.
Oh, they saw it.
Yep. And you believe what they said.
Okay.
Are you okay in that circumstance? Could you do it?
Yeah, I could do it if they saw, well, it wouldn't be impossible. It would be, I think it's the other juror. It would be difficult. I don't know if it would be impossible, but.
Okay. Understood. Moving now to the right-hand side. Raise your hand if you feel the same way that some of these jurors have expressed. Very difficult or impossible. All right, I see a hand from seat 14, seat 15, seat 55, and seat 57, and seat 38, and 54. Thank you, sir. Seat 14 has a microphone. Go ahead, sir.
I basically agree with what was said on the left side, that it'd be very difficult just because of the fact that sometimes people see and experience things. It's not always equal. And for that reason, it'd be difficult but not impossible. But I do agree that it'd be very difficult without any other evidence to kind of collaborate with the facts.
Okay. Thank you, sir. Seat 15, right next to you.
I agree. Difficult but not impossible.
Okay.
I mean, rely on facts, and if that was the only facts I had, it would be very difficult to do so.
Seat, I think 38 was the next number that I had in order. Yes, sir?
The biblical standard is in the law.
Your mic's not on. You have to figure it out. Well, it's on, but it's not registering. Nope, not yet.
Hello? Hello? Straight up front, yeah. Oh, now it turned on. Great. Can you hear me now?
Yes.
Oh, fantastic. As far as I understand it, the biblical standard found in the Levitical and in Deuteronomy, the law, and then reverberated in the New Testament, is that someone should not be condemned unless there's evidence based on 2 to 3 witnesses. Therefore, my foundation is that. I don't say it's, I say difficult but not impossible as a result of additional evidence to support. Namely, just as one example, if there was one witness and then video footage, just as an example,
right,
to reaffirm the witness position, that would be a good example where I could. So I guess the short answer is difficult but not impossible.
Okay. Thank you, sir. Seat 54?
Yeah, same thing. In the absence of any other evidence, it would be very difficult.
But not impossible.
Not impossible. No.
Yes, sir. 55.
Basically the same thing. Difficult but not impossible.
All right. And seat 57?
I think for me, like, there would always be a shadow of a doubt. So I think for me, it would be impossible if it's just one person's testimony and there's literally nothing else.
All right. So there will never come a time where anybody uses the word shadow of a doubt in this courtroom, in the law. I understand TV uses it all the time, but the standard that will be consistent as to our burden is beyond a reasonable doubt.
My apologies.
It's not your fault. You're not a lawyer, to my knowledge. So people use that phrase all the time. Okay? But I understand what you were saying, so thank you. Okay. And we're actually moving rather quickly. I'm kind of almost done. All right. Let me talk to somebody else I haven't spoken to yet. Juror in seat 7. How are you, ma'am? Yep. Let's give her the microphone.
Doing all right.
So at any time this morning, have you seen Mr. Buxman's feet?
No.
All right. You didn't see him in the parking garage or anything like that?
No.
He didn't cut you off in the...
No.
Okay, good deal. Because I warned him about that earlier. Have you ever heard the term circumstantial evidence?
I have.
What does circumstantial evidence mean to you?
That it's something that happens whether it was present but can't necessarily be admitted as any of the other testimony, things like something, a weapon is lying on the side of the road, but it wasn't necessarily used. Nobody could testify that they had seen it in somebody's hand, things like that.
Okay, that's not bad. Let me try to hear from somebody else that I haven't spoken to. Seat 39. Have you heard the term circumstantial evidence?
Yes.
What does it mean to you, sir?
Evidence or something that can't be used against that person.
Ooh, okay, now we're getting warmer, right? The reason I ask this question is because the term circumstantial evidence has obtained a negative connotation over the years. And what it basically means to most people, like can't be used as one of the descriptions. True, right? There was an example given by juror in seat 7 about a gun that just sort of found by the side of the road. So let me give you all an example and go to someone else I haven't spoken to yet. Seat 44. Can we give the microphone to seat 44?
Hello.
Hello. Have you seen Mr. Buxman's feet this morning?
I assume that they're there, but I have not.
You have not. Okay. Is Mr. Buxman wearing shoes?
I wouldn't be able to tell you that without seeing his feet, I guess.
Can you speak up?
I said I wouldn't be able to tell you that without seeing his feet.
Do Do you think he's wearing shoes?
I would assume.
Okay, you would assume. All right, why do you make that assumption?
Whenever he kicked the desk, it sounded like it had an echo.
That's a good one. Did everybody hear what she said? She said when he kicked the desk, it sounded like he might have had something on his feet, right? Can you think of
socks? Yes.
Can anyone else think of another reason, if you believe Mr. Buxman is wearing shoes, why he might be wearing shoes? Seat 23. You were the first one to raise your paddle.
Because there's a dress code in this courtroom?
There's a dress code, and downstairs, not just in this courtroom, but downstairs to come into the courthouse, it's sort of a no shoes, no shirt, no service kind of thing. Anybody else have a reason? Seat 19. We haven't heard from you yet, I don't believe. If you saw his feet, don't say that. Because sometimes people get tricky with me and they say, well, I saw his feet. No, go ahead.
I have not seen his feet.
Okay.
But I would think it would be logical for him to have on shoes with the outfit.
With the outfit, in other words, white feet don't go well with a dark suit.
With what I can see here.
With what you can see. Okay. So, anybody else have anything totally insightful on that topic? Seat 35. Yes, sir.
Well, if he has a wife or a significant other like me, she would never let me leave the house without shoes on.
A shoe check.
She would pull in my socks out and pick she picked what I wore today.
Oh, okay.
So
Okay.
I'm guessing its significant other wouldn't let him leave the house without shoes.
All right. Well, we're not going to get into Mr. Buxman's personal life, but so what you just heard was a good example of circumstantial evidence. You take facts that are observable and known, and from those facts you infer another fact. So you all know that there's a dress code in the courtroom, that Mr. Buxman has a dark suit on. There was the noise from the desk when he shifted his seat. Those are facts that allow you to infer that Mr. Buxman is in fact wearing shoes, and that is what circumstantial evidence is, right? The reason I go through this long example is because unless there's a new device of which I am unaware of, there is no way to know exactly what a person is thinking in his or her mind when they do something. But in almost every criminal case in the state of Florida, the state has to prove a person's intent at the time they did something. And the way we do that is by presenting evidence of what they did, what they said, and how they acted. So, my question on the left-hand side is, does anybody think that they're going to have an issue using circumstantial evidence to identify a person's intent? If you could raise your paddle nice and high. I see no hands. On the right-hand side, does anybody think that's going to be an issue for you? What about you, juror in seat number 12? We haven't spoken to seat 12 yet.
What's the direct question?
The question was, do you think it will be a problem for you to use the concept of circumstantial evidence when determining what a person's intentions were?
No, I don't believe it would be a problem for myself at all.
Okay, understood. All right, I have one more question, but it's a multi-part question, so don't get excited, okay? And it involves me telling one of you a story and then asking all of you your response to it. So somebody I haven't talked to yet. Seat 16. She saw me, she knew I was coming to her right away. And she looks like she just got called down on The Price is Right. She's so excited. I'm excited because you're excited. How are you, ma'am?
I'm good. How are you?
I'm well. I'm well. Okay, so I'm going to tell you a story, okay?
So excited.
I told you she was excited. So there's a woman who goes to work in the morning. She gets dressed in her house, suit on, walks out her front door. It's about 8:30 a.m. Turns around, locks the door behind her, walks out to her car, gets in her car, puts the keys in the ignition, starts it up. As she looks at her front door, or the front of her house, everything looks fine. Above her front door, there's a large window. The window is intact. She has her coffee in her little cup holder. She backs her mid-sized sedan that we all drive in the suburbs out of the driveway, pulls off and goes to battle I-4 traffic. You with me?
Yes.
Everybody else hear what I'm saying? Yes? Yes? All right, good. She goes to work, works all day, has a group project while she's at work. Drives home, pulls into the driveway a few minutes after 5 o'clock. And as she pulls into the driveway, there are two young men standing in the driveway. One of them is Joey, and the other one is Chandler. Okay? A couple of people. Joey has a baseball bat in his left hand. Chandler has a baseball glove on his right hand. Right? She gets out of the car, looks up at her house and at her window, and it's broken. You with me?
I'm with you.
Juror number 16, what is it that you think happened?
I think Chandler threw the ball and Joey hit it and it smashed through her window.
All right, did everybody hear what juror number 16 just said?
Yes.
Okay. Raise your hand if you reached or your paddle, excuse me, if you reached a similar conclusion, nice and high. Keep them up. Okay. A lot of people, not everybody, but a lot of people. All right, you can put them down. Thank you. So my next question for you, ma'am, is do you believe there's evidence at this point, beyond a reasonable doubt, that a ball belonging to Joey or Chandler broke the window?
No.
All right, thank you. On the left-hand side, raise your paddle if you believe, at this point on what you know, there's evidence beyond a reasonable doubt that a ball belonging to Joey or Chandler broke the window. I see no hands raised. Seat 33? Somebody pass him the microphone, please. But don't get comfortable, seat 16. I'm coming back to you. Yes, sir.
There's no evidence beyond a shadow of a doubt.
No, not a shadow. Reasonable.
Reasonable.
Beyond a reasonable doubt. Yes, sir.
So
not no for you at this point.
Right.
Understood.
Correct.
Okay, can we pass the microphone back to juror number 16? On the right-hand side, raise your hand if you believe at this point there is evidence beyond a reasonable doubt that a ball belonging to Joey or Chandler broke the window. I see no hands. Okay. So, seat 16.
Yes, sir.
The woman hears this. She goes up to Joey and Chandler and says, Joey, what happened to my window? And Joey says, Ross did it, right? And he points down the street. Ross is 3 years old, okay? So she dutifully walks down the street to talk to Ross, and Ross is riding his tricycle in the driveway. She stops him and says, Ross, did you break my window? Ross says, what window? Dutifully, she goes back to her house and across the street to the neighbor who lives across from her. Knock, knock on the neighbor's door. Says, neighbor, did you see what happened to my window? The neighbor comes out and says, you know, I came out around 4:30 in the afternoon to get my newspaper. I guess the neighbor sleeps late. And I saw Joey and Chandler pitching and catching and hitting a baseball in front of your house. Everything looked fine, so I went back inside. You with me?
Yes.
At this point, based upon what you've been told, do you believe there is evidence beyond a reasonable doubt that a ball belonging to Joey or Chandler broke the window?
No.
All right. Does anyone on the left-hand side disagree with juror in seat 16, and based upon what you know now, you believe there's evidence beyond a reasonable doubt that a ball belonging to Joey or Chandler broke the window? Raise it nice and high. See, I saw a paddle and then it went down quickly. Somebody pass the microphone to seat 47.
That was mine, so I guess I went up and down.
Yes, sir.
I thought that it would depend on it would be circumstantial still,
Right,
and circumstantial is evidence, and there's the two of them with the ball. I don't know, you didn't say how old these are these neighborhood children?
Joey is 6 and Chandler is 7.
Oh, well, then we're heading in the right direction.
Oh, okay, I'm glad you approve. But for you, is there evidence beyond a reasonable doubt right now?
No.
Okay, thank you, sir. On the right-hand side, does anybody believe there's evidence beyond a reasonable doubt at this point that a ball belonging to Joey or Chandler broke the window? Right, I see no hands. Does juror 16 have or seat 16 have the microphone back? Somebody pass it back to her, please. All right, so now the woman goes back to her driveway, And as she approaches the driveway, she notices that the window is not smashed out, but it's got a circular hole in it. All right? She opens up the front door, and looks inside, and there on the carpet is a white baseball with red stitching. At this point, juror in seat 16, do you believe there's evidence beyond a reasonable doubt that a ball belonging to Joey or Chandler broke the window?
Not belonging to them, so no.
Okay.
But there's evidence that a ball broke the window, but it doesn't necessarily mean that it belongs to them.
Right. So on the left, if you disagree, and in other words, if you believe at this point there's evidence beyond a reasonable doubt that a ball belonging to Joey or Chandler broke the window, raise your paddle. I see no hands. All right, what do you think? The juror next to you, juror in seat 17, can you pass her the microphone, please? We know it's on because she was using it, so.
I don't know if you can hear me now.
I can hear you just fine.
Can
you tell me what you're thinking?
I'm thinking I agree with her.
Okay.
I think I need more information to be able to make a decision.
Okay, fair enough. You keep the microphone now.
Oh, great.
Back on the right-hand side, raise your hand if you believe at this point there's evidence beyond a reasonable doubt, based upon what you've heard, that a ball belonging to Joey or Chandler broke the window. I see no hands or paddles. All right? Juror in seat 17. Now the woman walks over to the baseball, picks it up, and as she does, there on the other side of the baseball, scribbled in pencil, is the word Joey. You with me?
Yes.
Right? Do you believe, juror in seat 17, that at this point there's evidence beyond a reasonable doubt that a ball belonging to Joey or Chandler broke the window?
Yes.
All right. Raise your hand on the left if you agree with seat 17 and at this point believe there's a ball belonging to Joey or Chandler broke the window. All right. Please keep your paddle up nice and high until I call your number. So that's 1,
Let me hear the question again.
6, 7, 16, 17, 18, 22, 35, 36. C2 is making me go backwards. 2, 37, 48, 49, 50, and 51. Same question on the right-hand side. Raise your paddle if you believe there's evidence beyond a reasonable doubt that a ball belonging to Joey or Chandler broke the window. I see 8. You can put it down when I call your number. 10, 12, 14, 15, 23, 24, 27, 28, 30, 42, 43, 44, 45, 53, 55, 58, and 60. Okay. Yes, sir. You've got a paddle.
Yes, sir. I want to raise it so you don't mark me down. I got a question.
Yes, sir.
All right.
I'm sorry. That's seat 40 who's speaking.
Yes.
Go ahead, sir.
Okay, so the question is, a ball has broken the window that belonged to these two individuals, not that they broke the window, correct?
Yes, sir.
All right.
Let me say it slightly differently. It's a ball belonging to the individuals broke the window. Because the way you said it made it sound like the window belonged to them.
Oh, I got you.
But you're right. It's a ball belonging to them. I didn't say anything about them breaking the window.
So, yeah, I got
okay.
Yeah.
With a clarification, seat 40 raises his paddle. All right. Anybody else have any questions at this point? Okay. I see no other questions. So, let's seat 4. Can we pass the microphone to seat 4? Now, you have not raised your hand, right?
Sorry?
You have not raised your hand.
Correct.
On this question. So for you, there's a reasonable doubt about whether or not a ball belonging to Joey or Chandler broke the window. Is that fair?
Yes.
Okay. Tell me what your doubt is. Tell me about that.
The fact that the ball say Joey doesn't represent or doesn't establish the fact that the ball is labeled with Joey's name does not reflect or does not establish that that ball belongs to Joy.
Okay, what about next to you? Could you hand the microphone to seat 5? What do you think, sir?
I agree. With that.
Okay. Anybody else who has not raised their paddle have a different answer or has a different thought in their mind? I see seat 54. Could we hand him the microphone, please? Go ahead, sir.
I mean, kind of the same, the similar opinion. I mean, it doesn't necessarily belong to him just because it has his name on it. I mean, someone else could have wrote his name and like to frame him, possibly.
Right. Okay, so that's an affirmative response. We'll come back to that in just a moment. Seat 9, can somebody pass him the microphone, please?
Is he the only kid named Joey in the neighborhood?
You're asking for facts that I have not given you, and that is not allowed. But I think what you're saying is there could be another kid named Joey.
Correct.
Okay, understood?
I mean, beyond that, I mean, just because they're standing there, his big brother could have taken it and thrown it.
Well, I didn't say who broke it. I just said a ball belonging to them.
Right, but does it belong to them? It just has his name on it, a name on it, Joe.
A name, Joey. Joey. Yes, sir. Okay. It's important because there's more Joes than Joeys when you're talking about younger people. I saw another hand or paddle. 21, did you raise your paddle? Can we hand her the microphone, please?
Yes, it was similar to the fact of just because the name Joey is on the ball, is it technically his ball? Could be Dad's name.
It could be. Right. So, and I'm going to go back to seat 54's statement. You don't need to hand the microphone. No more talk from seat 54. I'm just kidding.
Just a minute, Jack. Can we approach?
Sure.
May I proceed, Mr. Williams?
Thank you, Your Honor. So I think where I was I was saying I was going to take seat 54's response. I believe if I misstated seat 54, you tell me, but somebody else could have wrote the name Joey on the ball, right? And sort of going along with seat 9, there could just be another random person named Joey in the neighborhood. Does everybody on the left agree that those are possibilities? Yes? All right. Seat 32? Hold on, wait for the microphone. Wait, that's okay.
What you're saying to an episode that happened to my own self when I was little with my brother. They were actually playing outside baseball, kicking ball, that's what we used to call it. It was a ball, his name was on it, but he just went to a bathroom break. He went to there was no kids around, so he thought that one of the kids has his ball, so he didn't came back home. And there was this lady very mad at us, saying that my brother was the one who broke her window because the ball was inside of her house with his name and everything, and he actually didn't do nothing. It was one of his friends. So what you're explaining right now is like, oh my God, he's telling the exact story.
Right. So, but I take it he wasn't in front of the window when it was broken.
No, he went outside and he realized that all his friends, they were gone.
Right.
So he came back home thinking, okay, one of them keep the ball, they're going to give it to me later.
And these two young men stayed in front of the house. But I hear what you're saying, and that's really unlucky for me, but okay.
I'm sorry, that's what I'm not right.
No, it's okay, it's fine. So I think the last question that I asked was, did people on the left agree that it's possible that there's another Joey or somebody wrote Joey on the baseball, and I think I saw everyone agree. Is that right? On the right, you all agree that that's possible? No. That was once again, C40 not using his paddle. Yes, sir. Tell me, you don't agree that that's possible?
No.
Tell me what you're thinking.
I think that the ball belongs to the two sitting in the front. He explained to the homeowner that the kid down the street threw it, but yet your ball is inside.
So you're pointing out that he gave a bogus explanation.
Absolutely.
I see. Okay. So for you, it's not possible. And now seat 5. So I should have started with Joey and Chandler because that's what it took to get you all talking, apparently. Yes, sir.
How old is Ross?
Ross is 3.
Oh, he's 3 and he's throwing the ball that far?
Yeah.
Wow.
Right. So believe it or not, I'm done with questions about Joey and Chandler. But I use it to point out that the definition of a reasonable doubt under the law is not a possible doubt, an imaginative, forced, or speculative doubt. And what the law and the instruction says that if you have such a doubt, it should not cause you to render a verdict of not guilty, right? That's the whole purpose of a reasonable doubt. You all will make the determination of what is reasonable and what is not under the facts. But just because something is possible or could have happened is not a reasonable doubt under the law. Does that make sense? Anybody not understand that concept? All right, I see no other hands raised. Could I have a moment, Judge? Yes. I told you I was almost done. Thank you all very much for your time and attention. That's all I have, Judge.
Thank you, Mr. Williams. All right, folks, this seems like a good time to take an early lunch break. We're going to start back up again at probably 1:30, so get here at 1:15 so we can line you up. If the jurors in seats 11, 13, 54, and 56 would remain just for a few minutes, and then you'll be released to go to lunch. So don't talk about the case, including to each other. Don't look up anything. Don't look at any news reports. If you see the attorneys, they will not speak to you outside this courtroom. They're not being rude. They're under instructions not to have contact with you outside the courtroom. So they actually won't even say hello. Please don't hold that against them. They're under court order to do so. Y'all have a good lunch. 11, 13, 54, and 56, please remain in the courtroom. If we can put, I'm going to leave 11 in here. If you can put the other 3 in the jury room. So these are the ones that want to talk to me privately. Okay, thanks.
Thank you.
Thank you. All right, ma'am, can you hear me? You wanted to talk to us privately in response to a question that was asked about both you being a victim of a crime and someone, either you or someone close to you, being arrested. Does she have a mic?
Which one?
All right, thanks.
Yes.
All right, go ahead, ma'am.
Okay, it was domestic in nature. And without going into too much detail, it was a while ago, like 2014 through 17.
Okay. Were you the victim of the domestic incident?
Yeah.
And the person that was arrested was your spouse, your boyfriend, your spouse?
Yes.
Okay. Are you all still together?
No.
Okay. Is there anything about the way that was handled by the police that you felt they didn't do their jobs?
No, they did everything that they could.
Okay. What about, was the case prosecuted, ma'am?
It was, he did get arrested after the fact. Then I put him on a restraining order for a couple of years.
Okay. And did you feel like it was handled correctly by the prosecution?
Yes.
Right. Is there anything about that incident that left you with a bad feeling about the criminal system?
No.
All right.
I've healed from that. It happened, and I'm stronger for it now.
Would it affect your ability to be fair and impartial in this case?
No.
All right. Mr. Williams, you wish to inquire?
No.
Ms. Miller, you wish to inquire? Thank you so much, ma'am. Enjoy your lunch.
Thank you.
Number 13, please. Seat 13, I mean. Just leave the paddle behind me. Yeah, thanks. All right, you wanted to talk to us privately about being a victim. You were a family member, and I believe you were a family member being involved in an arrest of some kind. Is that correct?
That's right.
All right, go ahead and tell me about that,
My
please.
partner assaulted me. It was domestic violence.
Okay.
Earlier, I spoke with you guys. I said he had PTSD. This was before he found out he had that. He then sought therapy. I think he was treated fairly. He was arrested for that. And I don't think it would affect my impartiality on this.
Are you all still together?
We are.
Okay, great. Thank you, sir. State, you have any questions?
No, Your Honor.
No, ma'am. All right, thank you, sir. Enjoy your lunch.
Thank you.
Juror in seat 54. All right, you indicated you needed to talk to us privately about an incident involving either you or a close family member being a victim. Is that correct?
Yeah, a close family member.
All right. Can you go ahead and tell us about that, please?
Yeah, it was actually in another country. I have a tati who lives in Haiti. Oh, my bad, my auntie. My auntie. Mm-hmm.
So your auntie was in another country?
Yeah, she's actually she lives in Haiti. She was born and raised in Haiti. She was in Port-au-Prince, and her husband actually killed her.
So your auntie was murdered?
Yeah, by her husband.
Were you there when this happened?
No.
Was there anything about that incident that you think would affect your ability to be a juror in this case?
No, not at all.
Okay. State, you have any questions?
No, Your Honor.
Defense? All right. Thank you, sir. You're free to go to lunch. We'll see you after lunch. Thank you. Juror in seat 56, please. All right, sir. You indicated you needed to talk to us privately about you or someone in your family being a victim or being involved in a criminal incident. What? Okay. How long ago was that? Did one or both of your parents get arrested?
Yes.
Okay. Are your parents still together?
Yes.
Anything about that incident that you think would affect your ability to be a juror in this case?
No, not that incident, no.
Is there some other incident that would affect you?
No, I'm just, you asked about circumstances. Nothing about my circumstances changed since Friday, but like, internally, like going back to work, missing a half day, you know, and I've been there 2 months, and I'm doing stuff. I felt bad for my dad because he was visiting for China Bond, and I was just worrying all weekend, so.
So you're stressing about childcare, life, being here.
Yeah.
If you were picked for the jury, do you think you could do your job?
After classification, I don't know if I could.
Okay. State, you may inquire.
I don't have any questions, Your Honor.
Defense? Do you have any questions? All right, thank you. All right, thank you, sir. You can go to lunch. We'll see you after lunch. Thanks.
Thank you. Do I need my towel or?
Nope, you good.
Not now. I'm not entertaining cause until the end. Okay? All right, folks. Take an early lunch. Defense, you're up after lunch. I'm going to start at 1:30, so get here a little bit before that. All right? Thank you.
I was gonna say, you stay back there.
No, ma'am.
Now, don't disappoint me and go back and your work. No, now I'm going to go to 7. We're lawyers.
All right, we're back on the record on State versus Loyd, who's present with his attorney, state attorney's office. Sure. Good, everybody? All right, welcome back, everyone. I hope you all had a good lunch. We're missing someone?
Up the elevator.
Okay. He's on his way up. The elevators are slow. Everybody have a good lunch? Did you get caught in the rain? You know, if you hold those masks over your head, the water runs right off them. I thought they said no. Welcome back, everyone. It is the defense's turn to ask questions. Ms. Miller, you may inquire. And you may remove your mask.
Thank you on both accounts. Good afternoon. It is now weird to be standing in front of you not wearing a mask. And I just want to say first, we appreciate that you all are sacrificing. Everybody in this courtroom appreciates the sacrifice that you all are making in being here. And so I don't want you to think that goes unnoticed. And I also want you to know that I appreciate, from your perspective, this seems tedious. And so what I would ask is you would show the same grace or appreciation that a man's life is on the line. And so all of us take this process very seriously, okay? And so I'm not trying to belabor the point. It's just a huge responsibility we're asking as jurors if you're selected. Everybody with me? Okay. Mr. Williams talked a lot about experiences that you all may have had with law enforcement that shaped your opinions on law enforcement, right? And some people have strong feelings one way or another about law enforcement officers that aren't shaped on specific experiences. We all come into this courtroom from different backgrounds, different walks of life, being raised differently, and that's totally okay. And so I want to, for the purpose of this conversation, sort of put out the law stuff and just have a conversation about our feelings, okay? And I know it's weird to ask that in a court of law. Juror in seat number 27. If I could start with you, sir. Excellent paddle holding. Would you, microphone. Would you agree or disagree with this statement? Law enforcement officers are deserving of more credibility, or they are more believable?
No, I would not agree with that.
Why not?
I think everybody's actions are judged by their own.
Okay. If I could ask you to pass the microphone to juror number 26, or in seat number 26. Juror in seat number 26, would you agree that law enforcement is deserving of more credibility, or law enforcement officers are more believable?
No, I wouldn't agree that they're more credible. Everybody's human. You see what you think you see.
Okay. And I see somebody nodding his head behind you. Juror in seat number 42, if I could ask you to pass that microphone. Other shoulder. I saw you nodding. Is law enforcement deserving of more credibility, or are law enforcement officers more believable?
Well, I think they are.
And what makes you say that?
They're held to a higher standard than we are.
Sir, I can't hear you. I'm sorry.
Can you hear me now?
Yes. He
They're
said,
held to a higher standard than we are.
Okay. And so the question, again, no right or wrong answers. And a cheesy analogy we sometimes use is that if this were an arson trial and your house burned down yesterday, you would probably not be the exact right fit for this case. Does that make sense?
Probably.
Right? And so, again, no right or wrong answers. The question is, the law requires each juror to treat all witnesses the same when they walk in this courtroom. As Mr. Williams said, you as a juror, if you're seated, can believe or disbelieve any or all of a witness's testimony. Okay. And some people say to me, no problem. And some people say, I'm going to give an officer just a little bit more credibility, or that person's going to start out a little bit ahead just because he comes in this courtroom, he or she, identified as a law enforcement officer. Does that make sense?
Yeah.
I'm sorry?
Yes.
Okay. And so it sounds like that's what I know, the mics are terrible, the masks are terrible. I appreciate you sticking with me. So if I'm hearing you correctly, it sounds like that's what you're telling me, that law enforcement... No, that's not what you're telling me? What are you telling me?
I just tell you they're held to a higher standard than we are. I don't know how to put that.
She can't hear you. Say that again for me.
They're held to a higher standard than we are. That's the only reason I said that.
Okay, but that would be about law enforcement categorically.
Yes.
Okay, and so if somebody comes into this courtroom, you are of the belief that that officer is held to a higher standard than somebody who's not an officer, right?
I would believe so, yes.
And it sounds like to me that would affect your opinion of somebody on the witness stand.
No, it wouldn't.
Why not?
Even as officers, they're all gauged on their actions, like you said.
Okay. Would you say if we were at a race and somebody's a law enforcement, if we're at a race, we're running a race.
Oh, race.
Okay, and somebody's a law enforcement officer, somebody's not a law enforcement officer. Does the law enforcement officer in the credibility race start out a little bit ahead for you?
I don't think so.
Okay. On this side of the room, which we identify as the right, I know you all are looking at us from the left. Does anyone feel similarly to juror in seat number 42, that law enforcement that law enforcement's held to a higher standard, was his words? Show of hands or paddles. Juror number 10. Tell me what you think, please. Oh, sorry, microphone.
I believe they are held to a higher standard, or we want to believe that.
Sure.
And so I believe coming into the courtroom, they would start higher. They might not end that way.
Okay. So, and I don't know if that made sense, what I was discussing with juror in seat number 42. You as a juror, if you're selected, can believe or disbelieve any or all of a witness's testimony, right? You could hear from a police officer and say, I don't believe a word that man said, or woman, right? And obviously the state's provided a witness list, Mr. Lenneman's provided a witness list. Both of those lists include law enforcement officers, which is why we're talking about it. And again, no right or wrong answers. For you, do you think law enforcement officers coming in identified as a law enforcement officer starts out a little bit ahead?
I do.
Okay. And so it sounds like to me, for you, you would have a little bit of trouble following that instruction of let's treat everybody the same until we hear from them.
And I think the hearing from them is what makes the difference.
Okay. And so, again, I don't know. We just met, right? Or we met several days ago when you had the good fortune of being in these chairs. And so I don't know what's going on in your mind. And some people say, I have no problem with that. And some people say, no, I know for me, I'm going to be thinking that this person, because he or she is wearing the uniform with the badge, the gun, that I just know that I'm going to start out believing that person a little bit more than if that person wasn't a police officer, and that's okay.
I believe I would.
All right, thank you, ma'am. Anybody else on this side of the room? Juror 50 in seat 58.
I agree.
Sorry, I can't hear a word you're saying. The mics are going in and out a little bit.
Can you hear me now?
Yes. Do you feel like you're on a cell phone commercial?
I don't necessarily think just because somebody's a police officer, they're telling the truth, but I would give them a little bit more credibility to start with.
Okay.
Just I think naturally than somebody that's not a police officer.
Okay. Where do you think that belief comes from for you?
I believe that the vast majority of police officers are good people and are going to do the right thing. I think at a higher percentage of a non-police officer.
But would you say that that's a belief that you have because that's how you were raised? You see what I'm saying? Or is there something that you can identify as like, this is where my belief about law enforcement comes from?
I think maybe just the way I was raised, being a veteran, my experience with police officers throughout my life. Again, I don't necessarily think that every police officer always tells the truth, but I would certainly hold them a little bit higher to start with.
Okay. And so then the follow-up question is, right, the judge is going to instruct, just because somebody walks in here, a police officer, you could hear from him, you could hear from an officer about his or her his or her training, experience, etc., and you can decide if I want to believe or disbelieve this person. The question is, because somebody comes in here as a law enforcement officer, before you hear anything they say that either lends itself to, yes, I believe this person, or no, I don't, does that person, just because he or she is a law enforcement officer, start out a little bit ahead for you?
Yes, I think they start out.
Okay.
I couldn't disbelieve what they're saying, but I do think they start out a little bit ahead for me.
Okay. And now I'm going to ask you to pass back to juror 42, because you're a head nodder, and so now I want to know what you think. I can see you nodding, so tell me now, it sounds like, or it appeared to me, based on your affirmative head nodding, that you agreed with the juror behind you.
Yes.
Okay. And so, all right, I don't need to belabor that. Thank you, sir. Anybody else on my right, your left side of the courtroom? Juror in seat 23. You had to know I was going to ask you. Tell me what your thoughts are. Do police officers, because they come into this courtroom identified as law enforcement, start out a little bit ahead than somebody who's not a police officer?
No, they do not.
Why do you say that?
I do agree that they're held to a higher standard, but that's the way they conduct business and how they present themselves outside. We're supposed to be treating everybody equal that walks through here and judging their testimony based on what they're giving, not their status. So, yeah, no.
Okay. And that's where, again, there's going to be what's called direct examination and cross-examination of during the state's case in chief, and then flipped during the defense case in chief. And if you hear from an officer about his or her training and experience and you think, man, I really believe this officer, that's totally okay. The question is, for some people, because somebody comes in here identified as a law enforcement officer, because of our background, walks of life, some people just believe police officers more. Does that make sense?
It does.
Is that you?
No, ma'am.
Okay. I'm now going to go to the left side, your right side. Anybody show of paddles agree that law enforcement starts out more believable or more credible than somebody who's not law enforcement? Juror 37, tell me what you think, please.
I think they are more believable, in my opinion.
Okay.
Just because what they do every day and the sacrifices they make, it takes a certain type of person to be able to do that. So personally, yes, I think they are more believable. And I deal with them, I work with them daily, so I've seen them have my back. I've seen, on a daily basis, them conduct themselves and how they act. So my personal experiences make me feel that way.
Okay, and that's exactly what I'm looking for. And there's no right or wrong answers. I'm not trying to talk anybody out of their beliefs, right? Just figure out what they are.
Yes, ma'am.
And so again, the question becomes then, once a witness takes the stand, you can believe or disbelieve, if you're seated as a juror, any or all of that witness's testimony. It sounds like what you're telling me is before you hear anything, you're inclined to believe somebody who is identified as a law enforcement officer.
I wouldn't necessarily say I believe them, but I would be more inclined to, I don't know how to explain it. I would believe them. I would have no reason not to believe them. I would believe that they're going to tell me the truth, absolutely.
Okay. And so the analogy that I used over here, if there are two people at a race, it's a silly example, but if there's two people at a race and one is a law enforcement officer and one is not, does the law enforcement officer start out ahead for you?
For me, yes, ma'am.
Okay, thank you, sir. Anybody else, show of hands? I'm gonna have to call on some folks. Juror number 5, if you don't mind. Is a law enforcement officer deserving of more credibility or more
No.
believability? Why not?
Because I know police officers, a lot of them, they lie. Some people lie. It's all about the evidence. It's all about what's presented. I don't necessarily hold anybody above any standards more than anybody else till I hear what it is the testimony is.
And so the follow-up question is, because somebody comes in, before you hear a word that that person has to say, just identified as a cop, it doesn't feel like you're
No.
saying, okay.
Absolutely not.
Anybody having a reaction or feelings they'd like to share? Juror number 33 in seat 33. If I could talk to you for just a moment.
Yes.
Does a police officer start out for you more deserving of credibility or believability than somebody who is not a police officer?
I think police officers, law enforcement, certain trade fields have respect.
Trade guilds, is that what you said, sir?
Trade, different
Got it.
jobs
Okay.
have as they walk in, would have more respect. Now, does that I'm not Italian, but my hands get going.
Yeah, no, I do it too. That's why they give me one of these. But she can't hear you if you don't use the microphone.
But do you, if our task is to look at everything fairly, one officer versus someone off the street, in my opinion, start at the same place. You may respect one more, but it doesn't mean you have to believe them until you see the facts.
Okay.
Ms. Miller, let me interject here for a moment. Folks, I'm going to read you the jury instruction on law enforcement testimony. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. That is the jury instruction that is read to jurors at the end. Ms. Miller, you may proceed.
Thank you, Judge. That makes sense, what the judge just said, Juror 33? Sure. Okay.
Yes.
I'm going to stick with you for a moment, if you don't mind, and switch topical areas. I want to talk to you about whether or not Mr. Loyd chooses to become a witness in this case. Okay?
One more time.
I would like to change topics and talk about something a little bit different, which is whether or not Mr. Loyd chooses to become a witness in this case. Okay? Would you agree with this statement? If the defendant doesn't testify, he's probably guilty.
No.
Why not?
It's up to the lawyer defending that person and that person
Okay.
to see if it is best for the case at hand.
Okay. And so you wouldn't hold that against Mr. Loyd if he does not become a witness in this case?
No.
All right. But what I mean by that is, again, there's no right or wrong answers. Everybody comes from different backgrounds, walks of life, personal experiences. Some people say to me, if I don't hear from him, I know they got to prove it, but if he doesn't tell me his side of the story, I'm going to assume he's guilty. Or that's going to be in the back of my mind when I'm deliberating. Does that make sense?
Yes.
Do you feel similarly?
That if the person on trial doesn't say something?
Yes, sir.
No.
Okay. That wouldn't affect your decision-making as to whether or not the state has proven Mr. Loyd guilty beyond a reasonable doubt?
Again, you got to look at all the evidence.
Okay.
And just because the defendant doesn't speak doesn't mean he's guilty or not guilty.
Okay, thank you, sir. And juror in seat number 47, I sort of saw you nodding or having some sort of reaction. What are your thoughts about whether or not the defendant testifies?
If the defendant does not testify, that is not evidence. So it's not evidence. So it's nothing I would consider.
Okay. But I guess, can you follow my point that some people
Yes,
think
ma'am.
if I don't hear from this person, that's going to be weighing in my mind?
No.
No. All right. So different question is, you understand that Mr. Loyd has pled not guilty by reason of insanity. Does
Yes.
that make sense?
Yeah.
And so he's not disputing committing the act. He's saying, I am not responsible because I was insane. Does that make sense?
Yes.
Okay. So for you to make the decision about whether we have proven him not guilty by reason of insanity, would you need to hear from Mr. Loyd to reach that verdict?
No.
Same sort of logic? Whether we meet our burden or not has nothing to do with whether or not he testifies?
Right. It'll be the evidence and the testimony because by myself, I'm not qualified to assess sanity.
Well, you are going to be
I'm not
asked if we have proven that by clear and convincing evidence. So the state has to prove all of the elements of the crime and that Mr. Loyd is the one who committed those elements. But then when it comes to not guilty by reason of insanity, the defense has the burden. It's one of the few times the defense ever has a burden, and we have to prove by a lesser standard that he's not guilty by reason of insanity. Does that make sense?
Yes.
Any problem with whether or not he testifies in reaching either of those decisions?
No.
Okay. I'm going to talk now to what I'm going to identify as the left side of the room. You all are on the right. Anyone think, you know, if I don't hear from him, it's because he's guilty? Show of hands or paddles? No right or wrong answers? You know, if you don't volunteer, this is where Mr. Williams and I do agree, we call on folks. Juror number 51.
Yes, ma'am.
Tell me what your thoughts are. Would you agree with this statement? If a defendant doesn't testify, chooses not to testify, it's because he's guilty?
No, I do not concur.
Why not?
It may be in his best interest. Maybe he wouldn't be persuasive. Maybe his lawyer says the case is going well as is. You don't need to get up there in front. We've done what we need to do. So by no means.
Okay. Would you agree with this statement? The state of Florida has to prove him guilty beyond a reasonable doubt of the crimes they've alleged.
That is my understanding what their aim is.
Yep. Or he's not guilty, right, if they fail to prove it.
Correct.
Okay. If they don't prove him guilty, whether or not you hear anything from this side of the courtroom, does that change whether or not they've met their burden? Does that make sense?
Your question, but I would probably. She's been what the law is in different situations.
All right, hold on then. I'm going to read you the jury instruction on this.
I was saying, she will continue to do that.
In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. You may proceed, Ms. Miller.
Thank you. And so back to you, Juror 51, in seat 51. Your juror number is, in fact, 505. It's a little bit confusing. Again, some people say to me, no problem with that. Some people say, I just know for me that I'm going to be thinking about whether or not he took the witness stand when I'm deciding if the state has met its burden in proving him guilty. Okay. And again, I want us to imagine that we're having these conversations like 3 weeks ago, before you knew anything about Markeith Loyd or jury summons, if we were just having coffee and we were having these conversations, right? Because again, I don't think anybody is setting out to try to not follow the judge's instructions by any stretch of the imagination. With me?
Yes, ma'am.
Okay. If I could ask you, let's go next door, 52. What do you think? Would you agree if a defendant doesn't testify, it's because he's guilty?
No, I don't agree.
Why not?
there's different reasons that somebody may or may not want to testify. So, and it may be, you know, he may be listening to his lawyers if they advised him not to testify.
Okay. And so I don't think I articulated this well to your neighbor. The state goes first, right? And so they have to prove him guilty. If they fail to do that, whether or not we do a thing over there, he's still not guilty, right?
Yes.
Does anybody on this side of the room disagree with that? Or not understand what I'm asking is probably a better question. I'm going to come way down to the front. Juror number 1.
Yes.
Would you agree if a defendant doesn't testify, it's because he's guilty?
No.
Why not?
So it's not his burden to do.
Okay. And so the state's going to present evidence, whether or not they prove him guilty. If they don't, what we do, he's still not guilty. Does that make sense?
Yes.
Do you agree or disagree?
I agree.
Let's flip that now. You understand that Mr. Loyd has pled not guilty by reason of insanity. And that is something we as the defense attorneys have to prove by clear and convincing evidence. So beyond a reasonable doubt is the highest burden you as seated jurors would ever be asked to apply to facts. Clear and convincing evidence is more like here. It's a lesser burden. And not guilty by reason of insanity is still not guilty. And so a little bit of a different question. Do you think you would have a hard time saying I could find somebody not guilty by reason of insanity to this lesser standard?
No.
Okay. Any thoughts on that? All right. Thank you, sir. Let's juror number in seat number 2.
Yes, ma'am.
What do you think? If a defendant doesn't testify, is it because he's guilty?
No, ma'am. Just like the gentleman next to me, it's not his burden, and both sides have their own strategy.
And so whether or not they meet their burden has really nothing to do with what we do over here.
Correct.
We could, in theory, play cards. I suspect we're not going to do that,
True.
right? But they have to prove this. Maybe their case sucks. We don't have to do anything.
Exactly.
All right. Agree with that?
Yes.
Thank you, sir. All right. Coming to this side of the courtroom. Is there anybody who has strong feelings about whether or not the defendant testifies and whether that would affect your ability to reach a verdict in this case? I'm going to call on folks, but if anybody had any obvious thoughts they wanted to share, juror in seat 15, if you don't mind.
Do not. It's his Fifth Amendment right.
Okay. And again, I think most people, I think, understand where I'm going with this, right? I have a fear that somebody would say, you know, for me, in the back of my head, I would have a nagging feeling that if I didn't hear from him, it's because he's guilty. What are your thoughts?
I don't feel that way.
Okay. Switching to not guilty by reason of insanity, right? That is a different question than has the state met its burden, right? So now the defense has assumed a burden of proving something, and that is that Mr. Loyd was insane at the time of this incident.
Okay.
Do you think to reach that kind of decision, whether we've met our burden, Mr. Loyd would need to testify?
No.
Same logic?
Yes.
That it strategical or whatever?
Correct.
All right, thank you, sir.
Welcome.
Juror in seat 41. I saw you nodding. Sorry. That's what we do watch for head nods and eye contact and avoidance of eye contact.
You're good.
What do you think? If the defendant doesn't testify, is it because he's guilty?
No.
Why not?
He has the right to remain silent.
Sure. Can you appreciate sort of what I'm getting at is that some people think if I were in those circumstances or, you know, I heard what the judge told me, but I know for me, it's going to really bother me.
Yeah, twisted there. No, he doesn't have to speak. I feel he doesn't have to prove his innocence, and I wouldn't put any weight on that, no.
Okay. So that's what there's going to be two, in the first part of this trial, there's going to be two questions asked of jurors, really. Has the state proven each and every element of every crime alleged, and that Mr. Loyd is the person who committed those crimes, right? That's like one, is the state proven beyond a reasonable doubt he's the person who committed these crimes?
Yes.
Question two is, have we met the burden of proving that he's not guilty by reason of insanity?
Yes.
So not disputing that he did the acts, saying not legally responsible because I was insane.
Yes.
Do you think to make that second decision, you would need to hear from Mr. Loyd?
No, absolutely not.
Same sort of logic. You could hear from other witnesses, decide if we've met our burden, and whether or not Mr. Loyd chooses to become a witness has nothing to do with it.
Yeah, it has nothing to do with it.
All right, thank you, sir. Anybody feel differently or want to share thoughts? I promise it's more fun when it's interactive. No? I don't have a lot more. So a topical area I want to address, as Mr. Williams discussed, there are things that are less than pleasant involved in this case. And we're not suggesting anybody wants to look at autopsy photos, but it may be part of the state's case in chief or the defense case in chief, right? Another thing you may hear is profanity or racial slurs. And so I want to know if anyone is so offended by use of the word cracker that you think it would affect your ability to fairly try this case. Anybody show of hands, right side or left side? I'm seeing no hands. Juror 46 and seat 46, if I could come back to you. What are your thoughts about if you hear profanity or the use of racial slurs in this case? Will that affect you in your ability to render a verdict?
No, ma'am.
Okay. Any thoughts about that at all?
No, ma'am.
Okay. Let me ask you a different question since you've been kind of tucked away in the back corner.
Sure.
Law enforcement officers, do you believe they're deserving of more credibility or more believable than somebody who's not a law enforcement officer?
No, ma'am.
Why not?
All human.
Okay. Capable of making the same mistakes as anybody else?
Correct.
All right. Thank you, ma'am. Anybody on this side going back to racial slurs, profanity that thinks, if I hear somebody called a cracker, I am going to be so deeply offended that I'm really not going to be able to listen to everything else. Does that make sense? On the left side, your right side, does that resonate with anybody? Anybody have anything they want to share? Okay. Seeing no hands or paddles? On my right side, your left side, anybody offended by the use of the word cracker to the extent that it would affect your ability to try this case? I'm seeing some head nods no. Anybody think yes or have thoughts they want to share? I'm seeing no hands or paddles. May I have just a moment, Your Honor?
Yes, ma'am. All right, thank you. All right, ladies and gentlemen, I know you'll just be disappointed to hear that we don't have any other questions for you all. Actually, before I make that promise, let me see the attorneys at the bench for a minute, please. Okay. Here's what we're going to do. We need to speak with juror number 6 for just a few minutes. The rest of you, we don't have any other questions for you. You don't need to come back outside this courtroom until about 3 o'clock is what we're going to do. When you come back is we're going to tell you who's on the jury. And you don't have to wear those masks anymore. You can switch back to your regular mask. Please do not steal my paddles. Leave those in your chairs. Everybody but juror number 6, you can exit. You can go downstairs to the snack machines. If you're a smoker, you can go outside, but you need to be back outside in this hallway by 3 o'clock, please.
Stand next to you here so they can get out. Yep.
All right, sir, we just need to ask you some the first part of the questions that you missed. So your juror number 6 and your juror number badge is 30, correct?
Yes, ma'am.
All right. I only have a couple up for you, and then the state and the defense will have some. My first question is, has anybody talked to you? Have you seen anything or read anything since the last time you were in court about this case?
No, ma'am. Nobody's spoken to me. I have spoken to my job and to my family about what's going on, but nobody has spoken to me.
When you mean about what's going on, you're talking about the fact that you may have to serve as a juror?
That is correct.
Or the facts of the case?
That I may be selected for a jury.
All right. Have any of your circumstances changed since we first spoke?
I was involved in a car accident last night with all the rain.
Okay.
And a state trooper was not able to come out because of the activity. So I have this vehicle accident thing that I'm trying to get straightened out. I wasn't aware that I needed to be here today. So I haven't been able to kind of level set with my company to get things straightened out if I was not going to be in office. Our COO is going to be out for this week on vacation, which makes me the next senior person at the organization. Maybe a bit of a hardship. We lost our IT guy 2 weeks ago, and the next closest thing to an IT person that would be there to support the business. I have a follow-up COVID shot on Thursday that I think I mentioned the last time that I was here.
Is that your second shot?
Yes, ma'am.
Okay.
And I do not have any bags packed. Wasn't aware I needed to be here today.
Did you not call on Friday?
Friday is the only day that I did not call, and I called every day, sometimes twice. I dialed extension 6. I got no feedback about my group except for Friday. There was also a note that said if you call and there's no info, we may call you. So I just kind of assumed somebody was going to call me.
Okay. All right. Thank you, sir. State, you may inquire.
Thank you, Your Honor. You don't happen to recall what question I was asking when you came in this morning, do you? And if you don't, it's okay.
I cannot recall.
That's okay. So, just like it has been for everything that we've done throughout this process, no right or wrong answer so long as it's your truthful opinion, okay? The first question I have for you is, as you can imagine, in a homicide trial, there will be some photographs of a somewhat graphic nature. Generally speaking, when there's a first-degree murder, an autopsy is performed. The medical examiner is called to testify, and photographs from the autopsy are shown with as limited number as possible. Is there anything about you that you think you could not physically look at the photographs without becoming ill or anything like that?
I do not think I would become ill by looking at pictures.
Do you think, or would you become so emotional that you could not focus on the evidence if you were required? Because no one wants to look at them, but if you were required to look at the photographs for purposes of evidence.
I do not believe so, no.
All right, thank you, sir. Have you or anyone close to you ever been the victim of a person's crime? And by that I mean a crime where a person either put their hands on you or a loved one, or verbally threatened them from a close distance. In other words, I'm not asking about a car burglar or anything like that, but a person's crime. You or anyone close to you.
Been involved in what sort of incident?
A what? I'm sorry?
Been involved in what sort of incident?
An incident where you or someone close to you was the victim of a person's crime. Somebody put their hands on you or a loved one in a violent way.
No, not that I can recall.
Okay. Have you or anyone close to you ever been arrested that you can recall?
Not. I believe my father may have been arrested when I was a child at one point for a traffic incident. That's all that I can recall, though.
Okay. Since you're having a hard time remembering it, I'm guessing it wasn't a memorable experience.
I was a very young person at that time. I may have been 5 or 6 years old.
Do you have enough of a memory to know or say whether or not he was treated fairly by law enforcement?
No, I can't answer that question.
Anything about your memory of that experience that you think would prevent you from being a fair and impartial juror in this case?
I do not believe so, no.
Now, this sort of dovetails into that, so I'll ask it now. You were asked questions about the ability to weigh a law enforcement officer's testimony equally at the start with a non-law enforcement officer's testimony. Do you have any issues with that general concept?
I do not.
You think you could do that?
I believe so, yes.
All right. Have you or anyone close to you ever had a bad experience with law enforcement? So my understanding is it certainly wasn't an arrest, but a traffic stop where the officer was extremely rude to you. You saw something a police officer did that really affected you. Anything like that that we should be aware of?
No, sir.
Were you present, sir? Do you remember being present for the questions about law enforcement?
I do not believe I was present for that question.
Okay. So there's, as there has been with everything, there's an instruction on the law that the judge will give you regarding when a law enforcement officer can use force to effect an arrest or perform his or her duties. Make sense?
Yes.
Generally speaking, do you believe, well, and let me back up again. Sometimes that force will be deadly force. Certainly you're aware of the fact that law enforcement at times uses deadly force, right?
I'm aware of that, yes.
Right. Do you believe that it is never appropriate for a law enforcement officer to use deadly force to effect an arrest?
I do. Appropriate.
Okay, so you think there are times when they can use deadly force?
Yes.
Right. Do you think that law enforcement uses deadly force too often in our society today?
I do not believe that.
So is it your view, and I'm interpreting, if I'm wrong, tell me then, that law enforcement uses force or deadly force in the appropriate circumstances as a whole here today in our society?
To the best of their abilities, yes. There's always exceptions.
Right, understand that, and yes, okay. Were you present for the conversation about Mr. Buxton's shoes?
I was.
Okay, and I think that's all the questions that I have, Judge. Thank you, sir.
Ms. Willis. Ms.
You're
Willis,
welcome.
do you have any questions? All right, thank you, sir. You're free to join the other jurors. Come back by 3. Okay?
Thank you, ma'am.
Thank you. State, how long do you need?
call the judge. Please, thank you. 30 minutes, Judge, if that's okay?
That's fine. Defense? All right, 30 minutes. I'll be back. back on the record on State versus Lloyd. He's present with his attorney. State Attorney's Office is present. Y'all had enough time, or do you need more time?
Your Honor, we've had enough time. We did notice going through our notes that there are 2 jurors that have an issue we need to address with the court.
That have what?
There are 2 jurors who have a potential issue that we need to address with the court, but we're otherwise prepared.
Okay, go ahead.
So if Your Honor recalls, it feels like forever ago, but I believe it was last week, there was an issue about jurors having knowledge of Mr. Lloyd's injuries and the state not having exercised the strike on jurors who were not minority but had that information. So defense counsel at our request provided us with the numbers of those jurors. We went back and looked at the transcript of the jurors and feel comfortable based upon the transcript that they don't have that information. However, given that it was an issue that was raised, we wanted to make sure that it was on the record that specifically juror number 178 and juror number 369.
What seats are they in?
I'm sorry, Judge?
What seats are they in?
It'd be helpful if I gave you that, I know.
It's 26 and 38.
Okay.
Again, based upon our review of the transcript from jury selection, maybe more specific, because as the court has been, we've been getting rough drafts every day. We reviewed them and do not believe that they have any information about the cause of the injury. But since it was raised, we wanted to make sure that if defense counsel wanted to question them about that, we don't have an objection to them doing that individually.
Ms. Miller? You got to turn your mic on. Yeah, but you don't have it on your lapel. There's no way we're going to hear it if it's on the table.
This is a somewhat tricky position because the defense has continuously objected to jurors being stricken based on knowledge of Mr. Lloyd's injuries that occurred during the course of his arrest. However, if the court's rulings are consistently applied, juror number 178, who is in seat 26, when we spoke with him the other day, not today, the court asked about what information that juror had about this. The court's question was, how much did you hear? His answer was, basically what I remember most was the capture. Question, all right, tell me what you remember about that in as much detail. Answer, that he was captured and lost the use of an eye. Basically, that was it. And so what I would note also for the record is he is a white male. Obviously, we objected to the juror who was a younger black gentleman, played basketball in college. I believe there were 2 that we objected who had very similar information, one of whom the court asked if that juror could set aside that information, and the juror answered affirmatively, and the court still granted the state's cause. The other juror was the young man who is now a high school teacher who played basketball in college. The court did not inquire if he could set it aside, but essentially both of those jurors who happened to be black answered similarly to this juror, and this juror has not been struck for cause.
Did someone move to strike him for cause?
Juror number 178 was specifically not moved. There was no motion for cause despite the fact that we brought it to the court's attention.
Is someone now moving for cause?
No, Judge, we're just, the issue was raised, and we wanted the record to be clear that we reviewed the transcript and do not believe that they have any information. And if there's a question about that or concern, then individual inquiry would be appropriate.
If there's what?
Then if there's a question about whether or not they have information about law enforcement and the loss of the eye, this would be a good time to ask those jurors that question or those questions.
Are you moving for cause, Ms. Miller?
What I suggested the other day was that the state is only exercising cause challenges on
The
black
question I
jurors.
just asked you is, are you moving for cause?
I don't believe this is grounds for cause because this information should be.
So you're not moving for cause and you're not moving for cause.
That's correct.
You all want me to spontaneously cause a juror?
No, Your Honor.
I mean, I don't spontaneously cause people. It's not my job. Other than financial hardship, that one the court does. Yeah. So do you want him individually questioned, Mr. Williams?
No, we do not.
Ms. Miller, do you want him individually questioned on this issue?
No, the record is clear that he has information about Mr. Lloyd's capture and loss of the use of an eye. He is a white man, and we have exercised cause challenges
Okay.
differently.
So the court has the record which says, I remember he was captured, I remember he lost the use of his eye, and neither party moving for cause.
Yes.
Okay. Next, we have juror in seat, and neither party asking me to ask him more questions. Yeah, this is not the court's responsibility, all right?
We're not making it the court's responsibility.
So, no, I'm making the record. This is not the court's responsibility. I will bring him in here if either side wants to ask him questions.
Understood.
All right. So moving on to juror in seat 38, number 369. Yes.
It's the exact same situation.
Ms. Miller?
I think the record is already clear, which is why I'm not asking the court to ask additional questions. His testimony was, I remember seeing the defendant's face and some comments made about him potentially being involved with some police officer. And so again, this juror, for the record, is 369 in seat 38 today. These were the answers he gave during the course of the individual questioning. He is a white man.
That he saw the defendant's face?
Correct. And so the record is clear. If I can give the context of the entirety. The court asked, can you tell me what you heard? Answer, I don't normally watch the news, but I recall just kind of walking by the TV screen, and at the beginning of every news broadcast, there's kind of a cursory, hey, this is what's going to be going on in the program type of thing. And I remember seeing the defendant's face and some comments made about him potentially being involved with some police officer. For the record, the news coverage, if it showed Mr. Lloyd's face, he had a hole in his face and was bleeding pretty profusely from the night that he was arrested. And so again,
Where in that answer does it say he saw his face the night he was arrested? Did I miss you saying that?
Contextually, and I don't think there's a disagreement, I think we all interpreted him to say,
No. I do not interpret that as that being the day he was arrested. That's why I'm asking you the question. All I heard was a juror say, I was walking past the TV and I saw the defendant's face. And there were numerous, and now I'm thinking back almost 5 years, but there were numerous headshots of Mr. Lloyd that were posted by the news.
I appreciate what the court is saying. I interpreted his answer to mean his face on...
I understand I just wanted the record to be clear. You're saying everyone, no. I'm not interpreting the answer that way, all right?
And that's what, given the context of the question...
Right. Do you want this juror to be questioned further?
No, I am making a record that we are exercising cause challenges differently based on the race of the juror.
And are you moving for cause on this juror?
No, because I don't think that is grounds for cause, and I don't have a good faith basis to ask the court to do so.
State, are you moving for cause on this juror?
No, Your Honor.
All right, so I have two people that no one's moving for cause on with answers that could be followed up upon, but both sides declining to ask any more questions.
You got it, Judge.
Okay, thank you for bringing it to my attention.
Clear up, I do have a motion for cause on juror 38 related to a different issue.
Is it related to today's question?
Yes, ma'am.
All right, we'll get to him.
Okay.
All right? Let's just stick to one thing before the record becomes so tangled no one can follow it. All right, everybody ready to go? State.
We are.
Defense?
May we remain
Yes, you
seated?
can remain seated during this. Defense, you ready to go?
Yes, ma'am.
What says state to the juror in seat number 1?
State strike C1, Judge.
What says defense to the juror in seat number 2?
Defense would strike juror in seat number 2, 6094, because the court denied a cause challenge.
You don't need to stand during this, Ms. Miller. What says state to the juror in seat number 3?
Acceptable, Your Honor.
Defense.
Accept.
Juror in seat number 4, defense.
Accept.
State.
Acceptable, Your Honor.
Juror in seat number 5, state.
Acceptable.
Defense.
Accept.
Juror in seat number 6, defense.
Accept.
State.
State strike seat 6, Judge.
Juror in seat number 7, state.
Acceptable, Your Honor.
Defense.
Accept.
Juror in 8, defense.
Accept.
State.
Acceptable, Your Honor.
Juror in seat number 9, state.
Acceptable.
Defense.
Accept.
Juror in seat number 10, defense.
Accept.
State.
We would move the court to strike based upon her response on the law enforcement testimony question.
I apologize, I missed that. I don't object, I agree.
Okay. That juror struck for cause by agreement of the parties. State, seat 11, state.
State strike seat 11.
Ask for a race-neutral reason. Mr. Loyd is black, juror 11 is black.
State.
The general reason is her responses on capital punishments, specifically her response that she is of a Christian belief and she was unsure if she could vote for death, that God should make the decision in the end of someone's life. Though she ultimately said she could vote to impose a sentence of death, those comments give the state concern that she could actually do that. And she was on the fence, according to her language, about whether or not she had a moral or religious objection to capital punishment.
Hold on, let me get her original answers. All right, the juror did, in fact, according to my notes, make statements about religious beliefs about the death penalty, but she did say she would follow the law, but she expressed some religious qualms about it. Therefore, the court finds at this time, this is a black female, appears to be. The state has offered a race-neutral reason for the strike and grants the cause challenge.
We would object for the record.
And Your Honor, for record purposes, the state's 2 previous strikes were both white males, and the state did not strike juror in seat 8, who was a black female.
And by the way, that wasn't, I misspoke. It's not a granting of a cause challenge, grants the preemptory.
Understood, Judge. Thank
All
you.
right. Defense, juror in seat number 12.
Accept.
State.
Acceptable, Your Honor.
Juror in seat 13, state.
Acceptable.
Defense.
Accept.
Juror in seat 14, defense.
Accept.
State.
Acceptable, Your Honor.
Juror in seat 15, state.
Acceptable, Your Honor.
Defense.
I would exercise my second peremptory. Defense would exercise our second peremptory on juror 15 because the court denied our motion for cause.
Juror in seat 16, defense.
Accept.
State.
State strike seat 16.
Juror in seat 17, state.
Acceptable, Your Honor.
Defense.
Accept.
Juror in seat 18, defense.
Accept.
State.
Acceptable, Your Honor.
How many do I have? 11, 12. That's 12. I have 3, 4, 5, 6, 7, 8, 9, 12, 13, 14, 17, 18.
6 was struck, Your Honor.
6 was struck?
We used a peremptory on seat 6.
You're right, I just didn't cross him out. All right, so I have 11. Juror in seat 19, state.
Acceptable.
Defense.
Accept.
That's 12. 3, 4, 5, 7, 8, 9, 12, 13, 14, 17, 18, 19. 10, 11, 12. That's 12. Backstrike State.
No, Your Honor.
Backstrikes Defense.
Defense would exercise our third peremptory on juror in seat number 9, juror 427.
Defense, juror in seat 20.
Accept.
State.
One moment, please, Your Honor. No, Your Honor.
Backstrikes Defense.
Defense would exercise our fourth peremptory on juror in seat number 12, juror 686.
Your Honor, the state will request a race-neutral reason for the strike. All 3 prior defense strikes were of white individuals.
Ms. Miller?
And for the record, seat 12 appears to be a white female.
Similar to the state's argument on juror number 11, juror in seat 12 was much more enthusiastic in favor of the death penalty. She gave answers that suggested not only was she a proponent of it, she was more enthusiastic about it. And so in selecting a juror that's both necessary to consider guilt or innocence is also necessary if we get there to consider life or death. She is an objectionable juror because of her views on the death penalty for Mr. Loyd.
Court needs to check the original transcripts. All right, court is reading court's notes on this juror from individual voir dire. She did say she's a 6 or 7 on the death penalty as a possibility. She has an issue with racism as a mitigator. So I'm going to find that this one is race neutral and grant the strike. So we're at seat 21. What says the state?
Acceptable, Your Honor.
Defense? Backstrike State?
One moment, please, Judge.
Sure.
Thank you. If I recall, Judge, the question is to us on backstrikes?
It's to you.
Correct.
Yeah. And you said none.
Actually, we're going to backstrike seat 4.
Oh, you're backstriking 4? Okay.
Yes,
thank
Your
you.
Honor. He specifically indicated that he would have to be 100% sure to vote for death when asked questions about the death penalty during individual voir dire.
He did say that. He said beyond a shadow of a doubt. Court wrote it down. Give me 1 second, I need to make a couple of notes here real quickly. Court does find that to be a race-neutral reason. It's not even race, it's ethnic-neutral reason. The juror said more than one time, because I wrote this one down, more than once he said he needed it to be beyond the shadow of a doubt, holding the state to a higher burden. So I do find that's a genuine reason to strike him. All right, we're at juror number 22, I believe, yeah. Defense?
Accept.
State?
22 is acceptable, Your Honor.
Back strikes defense.
I have 1 moment.
I'll get with you, yeah. Your Honor, can I confirm who you have? I only have 11 jurors, unfortunately, by my count. 3, 5, 7, 8, 13, 14, 17, 18, 19, 20, 21, 22.
Defense accepts.
All right, that's the panel. We have one juror in seat 3, 5, 7, 8, 13, 14, 17, 18, 19, 20, 21, 22. Those are the 12. What says state to juror in seat 23 as the first alternate?
I'm sorry, Your Honor, I don't think you asked us about back strikes.
Yeah, I did. I thought I did. But in any case, you can backstrike up until I swear so. Do you have a backstrike on the 12?
We do.
Who?
Seat 7.
Seat 7?
Yes, Your Honor.
All right. State, you've used 6 strikes.
Yes, Your Honor, that's what we have. Thank you.
Okay. All right, juror in seat 23, what says the state? This would be the 12th juror. State?
Yes, Your Honor, acceptable.
Defense?
We would move to strike juror 905 in seat 23 because, using a peremptory because Your Honor denied a motion for cause.
Is there a race-neutral reason on him, do you think? Because that's another white male. I could ask.
Juror in seat 24, defense,
We accept.
state,
One moment, please, Your Honor.
sure.
C-24 is acceptable, Judge. Thank you for your patience.
Sure, no problem. Back strikes, state,
No, Your Honor.
back strikes, defense. That's the 12, 3, 5, 8, 13, 14, 17, 18, 19, 20, 21, 22, 24. What says defense to the juror in seat 26 as the first alternate?
How many strikes does Your Honor give for alternates?
Well, you've only used 5 of yours, so you have 5
That's true.
left. So,
I'd exercise a strike on juror 26 as the alternate.
all right, so that's your alternate strike. All right. Juror in seat 27, state,
Acceptable, Your Honor.
defense,
And so I can use my 5 peremptories on the alternates as well. And may I ask the court, how many alternates do you intend to seat?
depends.
Strike, use a peremptory on juror 27.
State, I'm sorry. So you're striking 27? You struck 26 and you're striking 27?
Yes, defense is striking jurors in seat 26 and 27, 178 and 2062.
Juror in seat 28, defense,
Accept.
state,
Acceptable.
this is the first alternate. Juror in seat 30. Who went first last time? State?
No, they did.
They
so it's our
did
turn.
state,
Acceptable.
defense.
Accept.
That's alternate number 2. Juror in seat 31. Defense,
Accept.
state,
State strike C-31.
juror in seat 32. Defense, state,
Move for cause on C-32 based upon her response regarding testimonial
No
evidence.
objection.
granted. Juror in seat 33. Defense,
We're exercising a peremptory because the court denied a cause challenge.
juror in seat 34. State,
Acceptable.
defense,
Accept.
it's the third alternate. Juror in seat 35. Defense.
Accept.
State.
Acceptable, Your Honor.
So if my records are correct, the state has struck 2 alternates, the defense has struck 3, correct?
That's what I indicate, yes, Your
All
Honor.
right, I have 4 alternates and 12 jurors. Juror in seat 36, state.
Acceptable, Your Honor.
Defense.
Accept.
It's alternate number 5. And juror in seat 37, defense.
To strike juror 30, in seat 37, 254 for cause, based on answers to giving law enforcement preferential treatment as far as credibility.
State.
No objection.
Juror in seat 38, state.
Acceptable.
Defense.
Move to strike juror 38 for cause. He has now referenced today Leviticus and Deuteronomy, which are both books of the Bible. On his individual questioning, he made reference to the ontological theory. And so at this point, it seems evident that there is at least some of his decision-making that is based on his faith, and rather than the court's instructions, I think there's a reasonable doubt as to his ability to set aside those faith value judgments. And so I'm moving to strike that juror for cause.
State. Response.
We object, Judge. There's no record evidence of that. He may be a theologian for all we know.
Yeah, he had a lot of, he quoted philosophers, he quoted theologians, he quoted a lot of people. But he did say he could follow the law. He just seems to be one of those people that is very intellectual and has all these quotes. So I'm going to deny the cause challenge. You want to use a strike on him? An alternate?
Because the court denied a cause challenge.
Uh-huh. Okay. Juror in seat 39, defense?
Accept.
State?
Acceptable.
All right, that's the 6th alternate. That would give us 18. All right, backstrike state.
One moment to put it all together, please, Judge.
Sure.
Thank you.
I would exercise one additional
Hold
backstrike.
on, it's not your turn. Hold on. Did 27 get struck? Yeah, he did. Okay, let me mark him off.
No backstrikes from the state of Florida, Judge.
Defense?
I would exercise a backstrike on juror in seat 5, number 220, because the court denied a cause challenge.
When did you make a cause challenge on him?
And that's what I was just conferring with my notes. We did move to strike juror number, who's in seat 5 now, 220 for cause, as a result of his answers to the individual questioning.
So you're backstriking him?
Yes.
What's that state to the juror in seat 40 as an alternate?
State strikes seat 40 as an alternate.
We'd asked for a race-neutral reason. He appears to either be black or Hispanic, but not white.
State?
I don't know that there's record evidence of what nationality he is, but he said that he wasn't treated fairly by law enforcement when he was arrested for a strong arm robbery. That's our race neutral.
Was that today? Those notes from today or the last time?
His individual questioning.
Yeah, I don't remember him saying that today. All right, let me see what seat number he was.
My recollection of that juror is he indicated he was not arrested for any felonies.
Hold on. Ms. Miller, wait until I ask
Oh,
you so that the record doesn't get hopelessly confused with you just talking. Now I've lost track of what I'm looking for. Hold on. 6, 7, there he is. I don't have any record of him saying that he was arrested. Do you have the transcript?
Not in front of us, but we can find it.
Yeah,
It was at the end of his questioning, and he indicated that he got in trouble when he was younger. And then the follow-up question was, how do you feel you were treated fairly? And he said no. Yeah, he did qualify it by saying he wouldn't hold it against the state.
I'm running a search for him, but I'm not finding him. Hold on. Yes, sir.
At the end of the state's questioning, Mr. Williams asked, something in my background and my experience may not make me a good juror for that type of case. He said, gotcha. I mean, Mr. Williams said, may not be, just ask me. He said, well, growing up, no, I have been arrested, not for any felonies or anything of the sort, but I mean, I don't have any bias towards anything, anybody or anything. You know, it's either you present the evidence, and if it's a fact, and you follow it. I don't judge people. Mr. Williams responded, understood. Were you treated fairly by the police and the system in that prior issue? His answer, not all the time. Question, would that affect your decision here at all? Answer, no, not at all, not at all. Everybody is different, you know, just try to present what's available, take into consideration, and then make your decision.
How is that answer different than that given by non-whites to the same question, or by whites to the same question?
I didn't hear the question.
The court's inquiry is this. I just didn't write it down, but we have other jurors who are not, well, who do not appear to be black, who gave that exact same answer and have not been struck. How is that answer different?
That the
What is
state-
it about him that causes concern?
The nature of the prior arrest.
The what?
The nature of the prior arrest. I know, but we know.
Is that all you have? Is that it?
It is.
In terms of your reasons for striking him?
Correct.
Ms. Miller? Ms. Miller, you wanted to say something?
I think the court's covered all of it.
Yeah, I'm going to deny that strike. I mean, we have other jurors that have given the same answers, and there was nothing about this juror that indicated to me. I didn't even write it down. That's how little it registered with the court that he had said this. That indicates to me throughout his questioning that he could not remain neutral in this case. All right, so that would make him the 6th alternate. Was that back strikes we were doing? Whose turn is it to back strike?
I don't recall, Judge.
I don't either. So back strikes defense?
We would use a peremptory on juror number 28. He's now been brought up as the 12th juror. And so we'd backstrike juror, in seat number 28, juror 68. Move for cause based on his relationship with Mr. Williams, and it was denied.
State? Anything you want to put on the record? They're striking juror in seat 28.
I heard, Your Honor. No, there's nothing on the record.
Okay.
Thank you.
So juror in seat 41, defense. And by the way, you have not used all 10 of your preemptories.
I know.
So I'm just letting you know because I don't want you to suddenly tell me, I've used all 10 of my preemptories. Go ahead.
We accept 41.
Defense?
We
Or, I'm
accept
sorry,
41.
state?
State strike seat 41.
Juror in seat 42, state?
One moment, please, Your Honor. No, Your Honor. Or maybe a better way to put it, I think, is acceptable. 42 is acceptable.
All right.
We're moving to strike juror 42 for cause. I don't know if the court wanted argument now or not.
Hold on, Ms. Miller. And I can't hear a word you're saying. Turn your mic on.
Is on.
Well, get it closer to your mouth. Because all I hear is like sounds coming from your table, but no actual words. All right. What says defense as to juror in seat 42?
We're moving to strike juror 42 for cause based on his answers today regarding law enforcement's credibility. He was a vociferous head nodder, indicated that law enforcement was more credible than non-law enforcement, agreed with everything juror in seat 58 said. Then we started with juror 42, then went back to juror 42.
State?
He was specifically asked the question if he would give them any more credibility. He said no. And then, as counsel pointed out, she went to seat 58, which I do believe is a cause challenge, and then went back to 42, who agreed. And then, Your Honor, gave the instruction about the law. So I do not believe 42 rises to the level of cause, given his prior response.
He was the juror
I
specific.
have enough, Ms. Miller, not until I ask you for another response, okay? I do not like spontaneous talking. Actually, I think there's enough doubt. I couldn't figure out whether he was going to give him more credibility or not, so I'm going to strike him. Juror in seat 43, defense.
We accept.
State.
Acceptable.
All right, back strikes, defense.
We have no back strikes.
Back strike, state.
One moment, please, Your Honor.
Sure.
Thank you. No back strikes, Your Honor.
All right, seat number 3, seat number 8, seat number 13, seat number 14, 17, 18, 19, 20, 21, 22, 24, 30. That is the first 12. Alternate 1 is seat 34. Alternate 2 is seat 35. Alternate 3 is seat 36. Alternate 4 is seat 39. Alternate 40 is seat 40 is alternate 5, and seat 43 is the 6th and final alternate. Alternates will be mixed in with the regular panel. Here's what we're going to do. First thing we're going to do is Mr. Loyd. Mr. Loyd, raise your right hand. I'm going to have you affirm. Do you affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, Mr. Loyd, if you had time to talk to your attorneys about jury selection. Have you been present throughout jury selection? Do you need any more time to talk to them about jury selection? And other than the objections your attorneys have already made, do you have any other objections to the panel that's being seated? I can't hear you, sir. All right. Thank you. All right, I'm going to bring these folks in. We're going to put them in the jury box. We're going to swear them in. We're going to release, after I've sworn the jury, I'll release the others. I'm going to send them into the jury room. We have spectators here for openings, so I'm going to bring them in. I have instructions for the spectators. I'll read preliminary jury instructions, and then you're going to do openings, no witnesses today. We have a scheduling issue to getting everybody to the hotel in a timely fashion. So once openings are done, you're done for today. I appreciate the state getting their witnesses here on time. Am I reading defendant not testifying during preliminaries or not? So you want me to leave out defendant not testifying? Okay.
Make one thing clear on the record.
Yes, ma'am.
Obviously, we have not exercised all of our peremptory challenges. However, we continue to object to the jurors being stricken for cause over defense's objection, and we believe that's embedded error that we're not waiving, and so don't accept the panel in its entirety.
You still have preemptories left. You don't want to exercise them?
No, I don't, and I understand the decision I'm making, but I do think that.
Thank you. All right, let's bring them in. You know how you're calling them, right? Because I'm going to tell them. that everybody? We're good? All right. All right, welcome back, ladies and gentlemen. How many of you missed your clear mask and want them back? All right. When you hear, the clerk's going to call your seat number and your badge number. Pay attention because we have some duplicate badge numbers in here, which is why we're calling both. So when you hear your seat number and your badge number, follow directions of the deputies. Go.
Seat number 3, badge number 27.
Come on up, sir.
Do I take this with?
No, you can leave the paddles.
Seat number 34, badge number 294. Seat number 8, badge number 215.
All right, have a seat, folks. I'll be right with you all. Those of you in the audience, you were not chosen for this case. We do appreciate all of the time and attention that you gave to the matter. You are released as jurors in this case. You're discharged. You're free to go home and unpack. Have a good day, folks. All right, ladies and gentlemen, welcome to the jury. You're going to be with us for the next 2 to 3 weeks, depending on how long all of this takes. Here's what we're going to be doing for the rest of today. I'm going to give you a quick rundown. I'm going to send you into that jury room because I know all of you have phone calls you need to make. So I'm going to give you time to do that while we set up for opening statements. So what we're going to do when you come back into the courtroom is I'm going to read you the preliminary jury instructions that are read in all criminal cases, and the attorneys will have an opportunity, if they wish, to do their opening statements. We're then going to go ahead and end for today, since we've got to collect luggage, get you to the hotel, get you all settled in. They do have dinner for you this evening at the hotel. I've been told it's around 6:30, so we'll get you there in plenty of time for all of that. So preliminarily, I do have a couple of questions for you all. Do I have anyone on the jury who's a smoker? We have one? Okay. How bad is the smoking habit? How long can you go without a cigarette? 3 hours? Not too bad. Anybody else who smokes? How long can you go? You're an occasional social smoker? Ma'am in the back, are you raising your hand? How long do you need to go without can you go without a cigarette? It's oh, you have a medical issue? I'm getting to those in just a second. Any other smokers? All right, medical issues. Anybody who needs to take medication on a regular basis? Okay, I'm going to let you give the deputies the schedule you need for that medication while you're back in that room, because I need to know how often I need to call breaks. And ma'am, do you have a medical issue you need to talk to me about, or can you tell the deputies and have them tell me? No? You said you had a medical issue? Do you need to discuss it with me, or is it something you can tell the Okay, I need you to talk to the deputies about that. Anybody who forgot prescription medications, didn't pack them? Good job. And we have one hand. You forgot some of your prescription medications? All right, I need you to, again, talk to the deputies, see if that can get worked out. If there's an issue, they're going to take it up with me, all right? We'll get you your prescription meds. All right, we'll make sure you have what you need. And then this is for the future. I've got my mask. As you notice, we all wear masks in this courtroom. I have my mask off so that you all can hear me, but I wear it whenever I'm not talking to you, and I plan to continue doing that throughout the trial. Is there any juror who has any COVID issues whatsoever that, that I need to know about now? That you're uncomfortable, you're too close, anything like that? You good? All right, I'm going to send you into the jury room. You can make phone calls. There'll be deputies in there with you to take notes, figure out what all the issues are. We're going to get all that resolved today. But when you come back in, preliminary instructions and openings. Okay? Thanks, folks. All right, can everyone in the gallery hear me up there? All right, folks, you are most welcome in this courtroom. Everyone is here because they have an interest in this case. It's a public courtroom. We're happy to have you. However, there will be no outburst of any kind, and that includes folks in the gallery talking to one another. No cell phones, turn them off. Not on vibrate, turn them off. You may not pull your cell phone out while you're in this courtroom. The deputies have been given blanket authority by me to remove people from the courtroom who are causing a disturbance or about to cause a disturbance. I will deal with it afterwards because I'm not going to stop the trial. As I said, and I can't emphasize this enough, everyone is welcome in this courtroom and welcome to watch this trial, so long as they do not disrupt the trial. And I am certain that none of you are going to do that. We're going to take, how long do you need to set up?
5 or 10 minutes at the most. We just need Your Honor to give us access to the monitors whenever it's appropriate.
I thought I had turned that on. Hold on. The monitor show is on to me. Check them and see if they are. Oh, wait, no, I'm sorry. Here you go. Did that fix it? Are we good? All right. Anything else the state needs?
No, Your Honor.
Defense, what do you need for your opening? Anything? Okay, so I need to give them time to talk to everyone. I'm reading 2.1 without the defendant testifying, not testifying, admonition. Hold on. I'm reading 2.1A, note-taking by jurors. I do not let jurors ask questions. That's all I'm going to, I need to read 2.2 if you're going to play are you playing the video in opening?
A portion of it, yes, Your Honor.
So it's an edited recording, correct?
It is.
I think, what's your position on me reading 2.2 since they're going to get it?
No objection.
State defense. And then I have 2.4, evidence of other crimes, wrongs, or acts, since I've authorized everyone to talk about the homicide warrant for the Dixon murder. Anybody want that one read? 2.4 as part of the opening instructions.
We don't believe it's necessary because what we say is not evidence. But
Okay.
I don't object to it if the court wants to give it.
Defense, you want me to read it or not read it? All right. All right, I'm not going to read it. If the jurors start to frown or look like they can't hear you, take your mask off when you're talking to them, because
So-
they've had trouble hearing us in this courtroom.
That was going to be my next question is, would the court permit me to not wear it so long as I stay socially distanced?
As long as everyone stays socially distanced, and socially distanced means that podium. You cannot walk, you need to not cross the line of the end of the evidence table. That's as far as any of you can get to that jury.
Understood, Your Honor.
All right.
Thank you.
All right. 4:15, I'm going to start reading preliminaries.
Thank you, Your
Unless I get an indication that the jury's running behind on what they're doing. The attorney's office is present. Everybody ready? Let's bring the jury back in. Everyone remain seated when the jury's coming in and out. You can go ahead and have a seat, folks. All right, welcome back, folks. Everybody get to make the phone calls they needed to make? All right, great. As I told you, we're going to start with preliminary jury instructions. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Markeith Loyd. Can you see me now? All right. This is a criminal case. Markeith Loyd is charged with first-degree murder of a law enforcement officer, attempted first-degree murder of a law enforcement officer, aggravated assault, carjacking, and possession of a firearm by a felon. The definition of first-degree murder of a law enforcement officer, attempted first-degree murder of a law enforcement officer, aggravated assault, carjacking, and possession of a firearm by a felon will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Markeith Loyd in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the arguments of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses and During the course of the trial, the court may take recesses. During these recesses, you must not discuss the case with anyone nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you're on the jury trying the case and ask that person to stop. If he or she persists, leave him or her at once, immediately. Report the matter to the court deputy who will advise me. You cannot have any cell phones, tablets, laptops, or other electronic devices in the courtroom. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, you are not required to take notes if you don't want to. It's left up to you individually. You've been provided with a notepad and pen for your use if you want to take notes. Any notes that you take are for your personal use. However, you should not take them with you from the courtroom. During recesses, leave your notes on the chairs. At night, they'll be collected and stored safely. No one's going to read your notes. After you have completed your deliberations, the court deputy will deliver your notes to me and they will be destroyed. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the opening, you're about to view or listen to an audio or video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that a recording has been edited should not concern you in any way and must not impact the way you view or listen to and consider this evidence. State, you may proceed. By the way, folks, videos show up on those monitors that are in front of you, as will documents throughout the trial. If your monitor is not working, please indicate so to me. I don't know that he has anything on there yet. You ready? Oh, is it off again?
It's off, right?
Your monitor's not working? Yeah, no one's is at the moment. Get AV up here, please. They were just working a minute ago.
That's not us.
Anybody's monitor coming up at all? I can see this when it's not coming up, so. Sorry, folks. Usually it takes longer in the trial before technology interrupts us. It's usually not the first moment of the trial.
I think we're good, Your Honor.
Thank you, Your Honor. May it please the court, counsel? On a crisp January morning, nearly 5 years ago, Orlando Police Lieutenant Debra Clayton lay on the asphalt, the cold asphalt of a Walmart parking lot mere miles from here. Her hip had been shattered by a .40 caliber bullet that was fired and entered the rear of her body, going through her bowel and her pelvis as she was struck by a shot from behind from her attacker that was chasing her. This first shot sent her to the ground, unable to run any further. Lieutenant Clayton was still armed. She had her gun, but she was wounded and little match for her still mobile assailant, who ran up to her, firing down at her as she looked up. The evidence in this case will show, ladies and gentlemen, that those were the last moments of Lieutenant Clayton's life before a second, and in fact what was the fourth .40 caliber bullet was fired into her neck and severed her carotid artery. More importantly, the evidence in this case will show that the man who chased her, who circled, who stood over her and held the gun, fired the shots that ended her life, was the defendant, Markeith Loyd. The evidence will go on to show that on that day, Mr. Loyd committed more crimes as the day went on, as he fled from law enforcement's efforts to bring him to justice. Now, the scene that I just described to you, Lieutenant Clayton's last moments, will be uncontroverted. And in fact, ladies and gentlemen, it was captured on video. Clayton. The evidence will show that Markeith Loyd fled from police, and in doing so, crimes of attempted murder of a law enforcement officer, and then carjacking and aggravated assault of a bystander who got in his way. But to understand the evidence of what happened on January 9th of 2017, you have to go back approximately 1 month. And the testimony from the state of Florida will begin with what occurred on December 13th of 2016. State's first witness will be Detective Savelli. Detective Savelli will tell you that he responded here in Orange County on that December 13th night to investigate a homicide. Yes, yes, Your Honor. So Detective Savelli responded to a scene on December 13th of 2016. And based upon his investigation, Detective Savelli went to a judge. Judge signed a warrant for the arrest for first-degree murder, the first-degree murder of Sade Dixon for the defendant, Markeith Loyd. Now, Detective Savelli will describe to you about how when a warrant is issued, law enforcement is notified so that any law enforcement officer who comes into contact with that person will be aware of it and can bring the person into custody. But what you will hear, unfortunately, ladies and gentlemen, is that no one from law enforcement came into contact with Markeith Loyd prior to the morning of January 9th of 2017. So we will quickly go back to that morning of January 9th, and you will hear witnesses who will tell you what occurred at the Walmart located at 3101 West Princeton Street here in Orlando, at the bottom right corner of the map on your screen. And the primary witness that you'll hear from will be a woman named Takeshia Bryant. Ms. Bryant will tell you that she went into the Walmart that morning after 7 a.m. and it was an unusually cold morning. She had a couple of her children with her, one of her children, her nephew, and she went in that morning to buy a jacket because her nephew wasn't prepared for the weather of the day. She'll tell you that she walked around the store, quickly found the item that she was looking for, and then she walked to a cash register near the front of the store to check out. When she went to the register, there was no, the light was on, but there was no present. So she and her nephew walked across the aisle to try to find someone to help them get out of the store and check out. She eventually found someone, walked back to register 2, and when she got back to register 2, there was a man standing there. He was wearing all black, with a beanie on his head and a shirt that said security in white letters across the front and back. And Ms. Bryant will tell you that she immediately recognized that individual. Ms. Bryant will testify that she recognized that individual because he had a relationship with one of her relatives, and she had seen on the news that he was wanted for the first-degree murder of Sade Dixon. She'll describe the clothing that we just discussed, and she'll tell you there was no doubt in her mind that it was the defendant, Markeith. Ms. Bryant will testify that she immediately became extremely nervous and in fact had to type the PIN number for her debit card in multiple times because she kept getting it wrong. And yet, while she gained her composure, the defendant standing right next to her, she calmly walked out of the store, and as soon as she got out of the store with her nephew, she ran. She ran because moments before, she had seen a police officer, police uniform, a black female, walk past her and out of the store to the right where her police cruiser, lights on top, was parked. And that police officer was Lieutenant Debra Clayton. Ms. Bryant will explain to you how she runs over to the car and lets Lieutenant Clayton know that the man standing at cash register 2 has a warrant for the murder of Sade Dixon. And you'll hear that shortly after that communication, Lieutenant Clayton calls for backup. She tells the other units that she's going to attempt to contact a suspect in a homicide investigation. Ms. Bryant will go on to tell you that a minute or so later, she hears gunshots while she's in the parking lot near the car. She quickly ducks down. The next time she's able to get up when the shots have ceased, she sees the man she identified as Markeith Loyd walking away, getting or jogging back to his vehicle before driving away. Ms. Bryant will not be the only witness that you'll hear from in the Walmart. You'll also hear from Julia Johnson. Ms. Johnson will tell you that she worked at Walmart at the time and that she was walking back into the store on the morning of January 9th when she walked past a man wearing dark clothing and a black shirt that had white security across the front. And you'll hear that Ms. Johnson identified the defendant, Markeith Loyd, as the man who walked past her. Significantly, Ms. Johnson will tell you that prior to hearing any gunshots that morning, she heard a female voice yell, "Stop, get down." And you'll hear the same testimony from Keisha Bryant, that before there were any gunshots that morning, she heard a command that she believed to be from an officer to get down, to stop. Similar testimony will come from another Walmart employee named Monica Pridgeon. Ms. Pridgeon will tell you that morning she was at the Walmart. She saw whom she believed to be Mr. Loyd. She ended up seeing or hearing the gunshots, and she will tell you it is definitively her view that Mr. Loyd fired first. These witnesses will testify, and you'll be asked to gauge their credibility, but yet again, it will be made easier because it's all on video. You'll see video from inside the Walmart following Ms. Bryant around. You'll see Markeith Loyd walking around the inside of the store as Lieutenant Clayton checks out from the cashier and walks out of the store in full police uniform on the morning of January 9th of 2017. The evidence will then shift to what happened after Mr. Loyd shot Lieutenant Clayton. You'll hear that he fled from law enforcement and that when officers arrived, they sent out on the radio a description of his vehicle. That's when you'll hear testimony from Captain Joseph Carter of the Orange County Sheriff's Office, longtime member of law enforcement. And Captain Carter will tell you that on that morning, a little after 7 a.m., he was driving south out of Apopka into the station to begin his daily work, when he heard the radio transmission with the description of the vehicle. He altered his path, coming out from the top left of Apopka, where he normally goes down 441, and he came down North Pine Hills Road because that was the last location that the vehicle had been spotted. And not long after he was going down North Pine Hills Road southbound, he encountered the vehicle, what turned out to be a 220 Mercury two-door coupe sitting at the stoplight of the lane. As soon as Captain Carter comes up to the light, he sees the car accelerating, he does a U-turn, turning on his lights and sirens. And he will tell you that the Mercury went only a small, short distance until it turned right into an apartment complex called Royal Oaks. Captain Carter will describe how he followed the vehicle into Royal Oaks apartment complex, and when they got to the second driveway, right, and it was a dead end. The Mercury stopped, and as Captain Carter pulled up behind the vehicle, before he could even get the door open and put his leg on the ground, shots rang out. And that a man wearing all black, a black male, fired at him. Captain Carter quickly got back into his vehicle and backed up. And again, ladies and gentlemen, you'll know that shots were fired because you'll see evidence that Captain Carter's vehicle was struck with a projectile. And you'll hear about the shell casing that was found at the scene. Captain Carter will tell you that he waited for backup and that the man who fired at him took off on foot. And you'll know that happened because Antoine Thomas will then testify. And he will tell you that he was returning to his apartment where he lived with his family in Royal Oaks just after or right around 7:30 in the morning. He had been getting coffee and he'd driven his 2013 silver Volkswagen Passat to do it. He parks in a space in front of his apartment building, walks in, at some point somebody yells, "Hey." Mr. Thomas didn't even know they were talking to him, but what he found as he rounded the staircase and got to the first landing was a gun in his face. And he will tell you that the man holding the gun was the defendant, Markeith Loyd. And you'll hear that Mr. Thomas identified Mr. Loyd from a photographic lineup that same day. Mr. Thomas will tell you that the man demanded his keys and that he was terrified. But in the man's hands, the man he identified as Markeith Loyd, he saw a firearm with an extended magazine, and in the other hand, another extended magazine. Knowing he couldn't catch it, Mr. Thomas threw the keys, hoping that the man would have to drop his firearm to catch them. And then he quickly turned and ran to his apartment. Additional witnesses will testify, and you'll see, again, video that Mr. Loyd, in fact, gets into Antoine Thomas's 2013 and then drives over and through a fence into a separate apartment complex in and around a residential neighborhood where he, for all intents and purposes, disappears. The remaining witnesses, most of the remaining witnesses, will be forensic witnesses who will describe their analysis and collection of physical items of evidence that shed insight on where Mr. Loyd went. One of those witnesses will be Dr. Joshua Stephanie, the chief medical examiner for the Office of the Ninth Circuit. Dr. Stephanie performed the autopsy on Lieutenant Clayton, and he will describe Lieutenant Clayton suffering from 4 gunshots. The first gunshot wound went into her right leg and exited from the same leg in the front of her thigh. A second, somewhat more superficial gunshot wound was in her stomach area. Then you had the gunshot wound from behind, just above her right buttocks, that fractures her pelvis and gets lodged near her stomach. And finally, the fatal gunshot wound to the right part of her neck that ends up killing her that day. You'll hear testimony from forensic witnesses who examined and searched the Mercury vehicle that was found at the scene where Captain Carter was shot at. And they'll tell you that when they searched that vehicle, they found items of clothing consistent with Mr. Loyd's employment and paperwork throughout the vehicle with his name on it. You'll hear that eventually, on that day, January 9th, law enforcement located Antoine Thomas's Passat at another apartment complex not far from the Royal Oak shooting. And that when they found it, it was backed in to a space with pretty extensive front-end damage to it, and you'll see photographs of that damage. Officer Paul Foster will testify that he searched the rear of that apartment complex that afternoon, and there on a balcony, wadded up, was some clothing consistent with what had been described as that worn by Markeith Loyd at the Walmart. What you'll find is that that evidence, that clothing was collected. It was sent to the Florida Department of Law Enforcement, and DNA analyst Sean Johnson will tell you that he compared a DNA sample from Markeith Loyd, and it matched the DNA sample that came off of the camouflage pants found in the apartment complex. We will then transition to the final portion of the forensic evidence in this case, which involves firearms. So you're going to hear from a crime scene investigator named Edward Vanderberg. Mr. Vanderberg will tell you that he responded to 1157 Lescott Lane, which is the scene where Mr. Loyd was apprehended. At that scene, he collected a bulletproof vest that you'll hear was worn by Markeith Loyd at the time he was brought into custody. CSI Vanderberg will also describe locating 2 firearms outside the residence where Mr. Loyd was found. One of those firearms was a .40 caliber Smith & Wesson SVE semi-automatic firearm. The other was a 9mm Glock Model 17 firearm. Eventually, near the end of the trial, you'll hear testimony from then Florida Department of Law Enforcement firearms analyst Richard Ruth. Mr. Ruth will tell you that he compared that .40 caliber firearm to 3 things. First, to a projectile that was recovered from the body of Sade Dixon. Second, to the 8 .40 caliber shell casings that were found in the parking lot of the Walmart at 3101 West Princeton. And thirdly, to the projectiles that were recovered from the body of Lieutenant Debra Clayton. And it will be his conclusion, based upon his expertise and experience, that the .40 caliber firearm found when Mr. Loyd was apprehended fired those projectiles, those bullets, and those shell casings. He will also tell you that the 9mm Glock that was recovered fired the shell casing that was located at the scene right next to the Mercury vehicle at the Royal Oaks apartment, where Captain Carter was shot at. That, ladies and gentlemen, will be the evidence and testimony in this case. That is what we will present to you during our case in chief, indicating that Mr. Loyd committed the crimes of which he is accused. But it will not, as you probably gathered from the questioning during jury selection, be the only evidence you will hear. So I want to take a moment to touch on a couple of topics that may come up. It may be suggested to you, first of all, that Mr. Loyd acted in self-defense. Now, I'm going to be candid with you. I will be candid with you that there is not proof beyond a reasonable doubt as to who fired first, whether it was Lieutenant Clayton or whether it was the defendant, Markeith Loyd. We just don't know that. But what the evidence will show is that Markeith Loyd had a warrant for first-degree murder on January 9th of 2017. That Lieutenant Clayton was aware of that warrant, bring him into custody. And thirdly, that she gave him commands to get down and obey and come into custody peacefully that were ignored. You will then be left with the law on her use of force and asked to make a decision on that topic if it's raised. The other topic, I'm sure you gathered, is a potential defense of insanity. And it is the state's belief that the defense will rely primarily on one expert, for his expertise and opinion that Mr. Loyd was insane at the time of this crime. I would ask that you listen for a couple of facts that are almost certain to come out. First, that this expert has a moral objection to the death penalty, was paid handsomely, and almost on behalf of the defense. Second, that according to the records that he reviewed, and records everybody's aware of, Mr. Loyd was never diagnosed or treated for a mental illness until he was charged with first-degree murder. And thirdly, you'll hear from the state's experts who will tell you that they do not believe Mr. Loyd was insane, and you'll hear from a defense expert who was paid by them who also says he was sane at the time of this offense. Now, as you've gathered, there's a lot of evidence that you're going to hear over the course of the next week or two. Our request, ladies and gentlemen, is simple: that you do what you've done to this point. Listen carefully to all the evidence that's presented before making a decision, and we are confident that when you do, you'll return a verdict of guilty as charged. Thank you.
I'll tell you in just a minute. Good afternoon. This case is a tragedy in death and a tragedy in life. You will hear from Dr. Toomer, who's been practicing 40 years, and he will tell you that he does not believe in the death penalty. And he will tell you because in his experience, it's not fairly applied. He's African American.
Objection, relevance.
They opened the door. When Markeith was 7 years old, somehow, some way, he was able to watch Roots and Mississippi Burning. And the questions that arose in his mind about the white man and the treatment of his people continued on throughout his life. And you're going to hear, and I'm going to tell you in a moment, that much of that is based in delusional thinking. He grew up in Carver Hill, moved to Pines Hills, would hang out on Orange Blossom, and at some point, like many young African American boys, he started selling drugs. His family didn't have much money, and he became the caretaker of his family. He would steal food and obviously get into conflict with the police. And the more the conflict grew with consistency, the more that he believed he was being targeted because of the color of his skin. Racism lived in his community here in Orlando. Him and his family saw members of the KKK marching by his house. In 1995, he was falsely accused and ultimately exonerated of a... In 1999, he went to prison. He went to federal prison till 2014. The original sentence was crack cocaine, and ultimately his sentence was reduced some.
Objection, relevance.
Thank you. And after spending that lengthy time in prison for the drug charges, he got out of prison in 2014 with the hope in his mind of a fresh start. He ended up getting many jobs including delivering chicken, which he was robbed twice. And throughout 2014, all the way up to late 2016, he continued to work. He had a house, he had girlfriends, he had family that he helped out. But the thought process that was created when he was 7 years old never went away. When Mr. Loyd was arrested on this charge, the police seized 30,000 pages of Facebook musing by Mr. Loyd. You're going to get to see some of that during this trial. And it will be clear to you that he's vocal about feeling that he's enslaved by the white man, that he's not a Martin Luther King, that he will fight violence with violence, and that he believes and follows accurately to the detail, and Dr. Toomer will tell you this, every one of the black males and black boy and women who have been killed by police officers. You will hear that even shortly after he was released from prison, he asked his sister Tanya to take out an insurance policy on him because he was convinced.
Relevance.
He was convinced that the police were going to kill him. So what are we dealing with here with Markeith Loyd? He doesn't think he's ill. He doesn't think he's mentally ill. That's called anosognosia. It's when a mentally ill person doesn't realize they're mentally ill. But he is. And actually about 30% of people who are mentally ill suffer from this issue. And you will hear from Dr. Toomer about that. Dr. Toomer will tell you that Mr. Loyd suffering the effects of underlying neurological impairment, major mental illnesses, PTSD, psychosis, and schizophrenia spectrum disorder, reflected in paranoid ideation, disturbance in thought process, delusional disorder, and anosognosia. Dr. Toomer will tell you that he believes, pursuant to the insanity instruction, that Mr. Loyd has a mental illness, and that although he knew what he was doing and its consequences at the time of killing Lieutenant Clayton, he did not know it was wrong. And he will explain that to you. But I want to talk about only a part of what Dr. Toomer is going to tell you. I want to talk about delusional disorder. Delusional disorder is a fixed, false belief that is not amenable to logic. It's important that you remember this, and Dr. Toomer will explain. A fixed, false belief that is not amenable to logic. That's what this gentleman has. You read his Facebook, that's what you'll see. He does not interpret things the way we interpret things. He has a fixed delusional system. And part of that is he believes, truly believes, that the police are going to kill him. That never changes. The heightened part of it does change, because you will hear that with fixed delusional thinking, these false beliefs can be heightened by stressors that will cause a person to react in a more significant way. It kind of makes sense when we're talking about stressors generally. I mean, we act differently when we're under stress. But there was an event that occurred in December that was a huge stressor to Mr. Loyd. And after this event, he was hiding in the woods, hiding in abandoned buildings, hiding generally. Didn't leave Orlando. He stayed here. And at some point you will hear that as this fixed false belief continued, as it did and as it was even before all of these events, that he was able to obtain a bulletproof vest while he was on the streets after this event had occurred. And he believed that was a sign from God. Now I want to talk about Walmart. Ed, can you help me out? You have great responsibility here in listening to the evidence and viewing everything very carefully, because I suggest to you some of it may be distorted. This is the front of the Walmart where the shooting occurred. Mr. Loyd had gone there because he was living in the woods and wanted food and water and to use the bathroom. And as you heard, at some point he was recognized by Miss Bryant, who knew who he was and that he was being looked for, and that she went outside to talk to Lieutenant Clayton. I would suggest that Lieutenant Clayton did not know who Markeith Loyd was. She was told about a murder case, but even as she was walking up to him, she wasn't absolutely sure. There had been no confirmation from radio dispatch, and all she was relying on was Miss Bryant. But you could judge that for yourself, because I'm going to give you, if they don't give you, the radio transmissions where you hear her talking on the radio and literally walking up to where Mr. Loyd was. And if you see that portion, if you remember that portion of the video they showed you, you don't have a lot of camera footage at the very entrance of the store. You have a door that people come in and go out. At that entrance, I think it's the pharmacy grocery area, if I remember correctly. Pharmacy grocery area. And what you see is, you see Mr. Loyd pushing the cart, and there's some film, I don't think they showed it to you all, but there's some film that shows she is walking with her hand on the gun and in the radio. And what you hear her say is they're asking questions. I think somebody from her unit, because she was in charge of a unit of officers, was asking, you know, what's going on, because she sent out an emergency signal. There's no question she sent out an emergency signal. And she says something like, well, walking up, there's apparently a Markeith Loyd, he's wanted for killing, and that's when she is walking up where you see her, because that's all she says at that point. Seconds are important. 8 seconds between that dispatch and her beginning to run in front of the building after Mr. Loyd flees. And what you hear after 8 seconds is emergency pursuit, bang, bang, bang. 3 shots. And that's all. Then if you watch the video that picks up from this area that shows this, and then you have a rooftop camera that shows down, which you saw part of. She's running along this area, and he's running behind this area. And what Mr. Loyd does, he's running. No gun. He didn't have a gun on him when he left to run away, and he didn't have a gun on him when he's over in this area. But what you see is him come around here, and he's running. And you'll see over here, I think I got a better... What you'll see is that she's running. Thank you. Appreciate it. She's running from the front here. He's running from behind here. Now, what you'll note is that when you see this, see where his body is turned? This is probably the first time he draws his weapon. She's here.
Objection, Your Honor, argument.
If you look at this, you'll see what the positions are his hands. The evidence is going to show that what happened was Mr. Loyd was running this way, next to this banister, and then he saw her, and he decided to change directions. So he comes around here. The evidence is going to show, we believe, that she fired at him. And that when she fired at him, he turns around, and that's the first time he pulls his gun. So he's being fired upon by Lieutenant Clayton. And you don't have to, believe me, if you look at the video carefully, and I'm going to introduce some videos, and they're going to introduce some videos, there is no question that he is not armed while he runs this way.
Objection, argument.
So what happens then? There's a gun battle. There's a gun battle between Lieutenant Clayton and Markeith Loyd. She's firing at him. He's firing at her. When she realizes, the evidence shows that at some point after this position here, where she's coming this way, she backs off and goes that way, which you saw in the video. So she changes the direction. But by that time, she has her gun out and he has his gun out. And they're firing at each other. How do we know they're firing at each other? This is something I got from the state. I'm sure they're going to introduce it to you. This is essentially the evidence that they plan on putting on that shows where each casing is. Where each casing is from what gun. Now, she had the 9mm Luger. He had the .40 Smith & Wesson. What you see here is Exhibit K is a 9mm bullet. There's one thing important. There's one casing missing because the police are trained to keep 16 bullets in their gun, and when her gun is checked, counting the ones that were fired, which were 8, she fired 8 shots during this period of time. And they found 7 bullets. That's 15, and there was 1 missing. And Detective Cadiz, who's the lead detective, will tell you that he found that out. Now, what is the biggest problem in this case? Besides you looking at evidence and making an evaluation of the evidence, and we'll get, at the end of the trial, get to talk to you about what our arguments are. But there's a big problem here, and that problem will come to fruition during the trial. There is a conflict with Orlando Police Department in this investigation. Is it one that we should be taken back about? No. Because everyone loved Lieutenant Clayton, including the lead detective in this case. And it was a terrible, terrible loss for everyone at the Orlando Police Department and the entire community of Orlando. Don't make any mistake, there's never going to be a question about that. There'll be other questions, but never a question about how well respected Lieutenant Clayton was. But what you're going to find out is that when the police start to piece things together, Detective Cadiz admits, after we found out, that he actually, when he put together a collage of the videos, going step by step by step, that he intentionally left out the one that shows Markeith running unarmed here and then turning. Left completely out. And that is the beginning of the conflict we see. I told you there was a casing missing, that was ignored. There was a projectile that was found on the other side of the parking lot. So there's another part down here. And that projectile was found after crime scene left the area. And so instead of bringing the main crime scene detective back to photograph it, show where it's at, collect it, they sent another detective just to collect it. And I would suggest that the evidence supports that that is a projectile that could have been fired by Lieutenant Clayton. You'll hear how Detective Cadiz will admit on their direct that he spoke terribly to Markeith. Told him he deserves the respect of a rabid dog. That's what the lead detective said to Mr. Loyd. Is that fair? It may be fair for someone who lost a loved one, who is angry, and hateful, believing that he took the life of.
Argument.
Sustain.
But this anger and hate, you will see, goes even further. Because the chief of police won't stop talking about it on the news.
Objection.
Sustained.
Ultimately, there is a significant manhunt for Mr. Loyd. Leave no bar undone. $100,000 reward. Vilified.
Argument.
Sustained.
And so, at some point, they're able to trace Mr. Loyd's phone through a wiretap that is being conducted. And on those wiretaps, they're able to capture conversation with Mr. Loyd, a friend of his, and his brother. And Mr. Loyd tells them that.
Objection. Calls for hearsay.
Sustained.
And so ultimately, after he is taken, or when they find him, Mr. Loyd puts himself in a position to surrender, waves a flag.
Objection.
Sustained.
And surrenders. Now, in terms of the investigation, I want you to pay attention to the incident with Captain Carter. So the incident with Captain Carter is, as you remember from the state, that Carter pulls up pretty close to where Mr. Loyd is, and Mr. Loyd gets out and shoots at him. He shoots the passenger tire. And Carter's never even out of his car at that point. So there's no question that he shoots, but where he shoots becomes important. And the evidence about that becomes important. There is no question that Mr. Loyd at that time, that he fired those shots, believed that Lieutenant Clayton was trying to kill him. That information is supported through Dr. Toomer's findings and through the evidence that you see.
Objection. Argument.
Sustained. Rephrase.
That the law the judge reads to you will describe for you so you can make the appropriate decision. And when it's all done, Mr. Loyd is going to be found guilty, not guilty by reason of insanity. And the reason not guilty by reason of insanity is because of Dr. Toomer's testimony. And there may be more. Thank you, Judge.
Thank you, Mr. Waterman. All right, ladies and gentlemen, I'm going to send you all to the hotel, get a good dinner, get a good rest. We will start back up with testimony tomorrow morning at 9:30. The state will present their case first. I'll see you then. Have a good evening, folks. Leave your notebooks on your chairs, please. Anything else from state?
No, Your Honor.
Anything else from defense? No. All right. I'll see everybody tomorrow. Court's in recess. What is it, Mr. Loyd?
Opening, one of my lawyers, he left out an important part.
We can't hear him. You got to mic him up.
I said he left out an important part of the defense, and also you allowed, and I told my lawyer to object, you allowed them to talk about a projectile coming out of Sade body, which has nothing to do with this case, and they didn't even supposed to bring that up. I told my lawyer to object, and he didn't. And then in opening, he left out an important part of my defense, which everyone should know, what these jurors should know, even Ms. Clayton's family should know, that wasn't told, because the state of mind coming from my Sade's thing, these people made up a story saying I came over here, banged on these people's door, and gunned these people down. I tried to turn myself in 2 times before Walmart. They don't want to talk about that. They don't want the jury to know. Walmart never had to happen. These people know that I believe the police were trying to kill me, and they told no one. They endangered Debra, me, and everyone else, but they told no one, and they trying to keep the jury and the people from knowing this. And this judge is working with them. And Walmart never had to happen. I tried to turn myself in 2 times before Walmart. I would never kill your queen like that. Never. And this wasn't told to the jury that's an important part of the defense. That's the mind state they had me in.
All right, thank you, Mr. Loyd. Court's in recess. Attorneys, you need to be here a little bit before 9:30, like 9:15, in case there's anything that comes up. Have a good evening, everyone. Thank you.